rise. Justices of the Appellate Division Supreme Court Court of Target. He, all persons having been to the Appellate Division. Right here, give your attendance and step here. Be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have over 5 hours of arguments scheduled for this afternoon. So please bear that in mind as I call the calendar. Remember that we have your briefs, we have the record, and we're fully familiar with the facts of your case. Okay. First case, People versus Jamel Brown. I'll do 7 and 2 and 7. Walsh versus Wallace Law Office. 5 and 1 and 3. B Destiny. If you would keep your voice up. Five and 2, 4 and 1, 5. Gonzalez versus 1436 Beach Realty. Five and 2 and 5 and 2. People versus Maximo de la Cruz. 5 and 2 and 5. Commission versus Mark Greenberg Real Estate. We don't have a respondent here. I'll give you 2 minutes. Okay? And a submission. I don't understand. I will give you 2 minutes. You'll be able to come up and you'll be able to tell us what your position is. Okay? You'll be able to make your arguments later on in the calendar when I call your case. You'll have 2 minutes to come up and speak and address us. Okay? You'll wait until then. I thought I had 10 minutes. You get the time that I assign, and there's no opposition. You are here by yourself. If there was opposition, I would have considered more time. Okay? Thank you. You're welcome. Manipal Education versus Tafeek.
Appellant requests 12 and 3 for rebuttal, please.
5 and 2, 5 and 5. I'm sorry, 6 and 2, 5 and 5. People versus Thomas Gregory.
Appellant requests 5 and 2.
5 and 2 and 5. Katz versus Augusto. Submitted. Lewis versus 96 Wythe acquisition.
Appellant 5 and 2, Your Honor.
Five and 2, 2 and 2 and 5. People versus Malik Bullock. 4, 1 and 4. Miller versus Camelot Communications. 6 and 2 and 6. Arok versus 391 Broadway is submitted. Lazama versus Judlow Contracting is submitted. First case for argument is People versus Jamel Brown.
May it please the court, Benjamin Brindis, intern at the Office of the Appellate Defender for Appellant Jamel Brown. We urge the court to consider all points raised in our brief, but today I will focus on points 1 and 2, that the video clips admitted at trial were not properly authenticated, and that the physicians and surgeons building was not a dwelling for burglary a second as charged in counts 3 and 4 of the indictment. Beginning with the video authentication issue, respondents concede on page 22 of their brief that neither of the standard means of authenticating video evidence were used in this case. People's Exhibits 1, 2, and 6 were all admitted through the testimony of Mr. Lucas Pena, who was not a maintainer, installer, or operator of the video surveillance system used in the buildings of the Columbia University Medical Center. And Mr. Pena was also clearly not a witness to the events that the videos show. He could not authenticate it using those standard means. In particular, the prosecution at trial relied on a circumstantial inference from these videos that cannot be drawn without knowing the videos and the times and the dates that the videos show. The videos do not show the theft of any laptop. There's no laptops seen in any of the videos. All these videos show are various people in hallways and buildings on the Columbia University.
Counselor, isn't that essentially a discretionary decision made by the court to allow that? Is it really an abuse of discretion based on what Pena described, what he did to copy the videos?
Yes, Your Honor. The Court of Appeals in People v. Patterson in 1999 decision required that there are standard protections and prerequisites for the admission of evidence like this, and there is none of that here. In particular, Your Honor, we draw your attention to People's Exhibits 1 and 2. Mr. Pena testified that he had nothing to do with the creation of these videos. They were handled in 2015 by some other member of the Columbia Public Safety staff, Mr. Lombardi or Mr. Lombardini.
But he does say that the CUMC, the Columbia University that you're referring to, operated and maintained a reliable video surveillance system. He says that the staff did daily maintenance checks, which ensured that the cameras were working. He testified that the surveillance footage was stored on a server that was accessible only to investigations and IT staff, and they had a responsibility to accurately maintain that footage. Why isn't that enough?
Your Honor, he had no
sufficient?
Excuse me. He had no basis for any of that testimony. His testimony is that the IT department maintained, installed, and operated the surveillance system. It was the smart computer guys, not Mr. Pena, that was maintaining and ensuring the accuracy of it.
Well, who was the system accessible to? Wasn't it only to IT and the investigative unit, and Pena is part of the investigative unit?
Your Honor, Pena never testified that he had access to the surveillance system. He testified that there was some bank, he calls it a bank, or at other times a server, maintained by the IT department.
Well, who could access that server?
He testified that that server or bank was accessible to investigations in IT.
Correct. IT and investigations, correct?
Yes, but the videos may have been generated somewhere else before they were put on that server or bank.
Well,
he's
the
not-
question, I'm sorry.
No, you can. I think what you're speaking about, because he does talk about the CUMC investigator Noel Lambertini. He says he downloaded the footage. He talks about that there's, they were free from any tampering. You're talking about more about a chain of custody, and there's no chain of custody issue with regard to a surveillance. There's nothing in any of what he's talked about with regard to the investigation. I'm sorry, the the investigation of Lambertini or the way that the video is kept that suggests that there's been any opportunity to tamper.
No, Your Honor, it's not a chain of custody issue. As you can see on page 109 and 110 of the record, Mr. Pena testifies that these videos were selectively edited. They would select snippets from a larger segment of video and put that together. Because Mr. Pena had no involvement with the creation of People's Exhibits 1 and 2, he could not testify that this was even one continuous video. It's not apparent from the video itself what time it takes place. And Mr. Pena says that the timestamp had been placed by the IT department before any investigations had access to it. Without knowing what time the things on the video occurred, the circumstantial inference that the person entering and exiting the areas where the laptops were purportedly kept can't be drawn.
But doesn't your argument, Counselor, go more to the weight as opposed to admissibility?
No, Your Honor. Without knowing what time these videos were taking, the circumstantial inference can't be drawn, and they have no relevance.
Except we have the time from the people who left the room. The people who were in the room, whose laptops were taken, were in the room at a particular time. We're able to say they left the room at a particular time, and that just so coincidentally is the time that your client goes in and out of the room. I mean, and those times that they state coordinate with the times on the video. So,
excuse me, Your Honor. No, the people who testified never appear on the screen at the same time, and the trial judge held.
No, I didn't say that the people who testified appear on the screen. I said that they testified as to the time that they left the offices.
I'm sorry, Your Honor. Their testimony was explicitly held by the trial court not to authenticate the videos. For Exhibit 6.
No, it doesn't authenticate, but it certainly does allow the jury to raise an inference with regard to the accuracy of the video.
I see my time is up. Can I respond to that?
Yes.
I'd also add, Your Honor, that the two witnesses from the 2017 incidents testified after the videos had already been admitted, and the authenticity is not a jury question. That is the judge's job to screen that evidence. Thank you.
Thank you.
May it please the court, my name is Sheila O'Shea and I represent the respondent on this appeal. I just want to clarify.
Well, counsel,
yes,
if you would, address the issue that counsel has talked about, the verification and the authenticity of the video and the fact that the person who keeps the video wasn't present to testify. The investigators who look at it, the videographers, or whoever is responsible for keeping it, not videographers.
Well, what Mr. Pena testified to was that he, in fact, downloaded all the surveillance footage from the so-called Z drive, and the Z drive was something that was maintained by the investigations division. So in that regard, and I believe he also testified that Lambertini would have downloaded the relevant footage from the actual server to the Z drive. So in that regard, there's no reason to believe that there was any inaccuracies or chain of custody issues. And for the reasons Justice Renwick identified earlier, the daily maintenance checks, which ensure that any issues would have been resolved promptly. Now, Mr. Pena has testified that he was under a business duty to accurately maintain the videos on the Z drive. I think that's important as well. And again, there was no indication that any footage had been altered. And again, with respect to the timestamps, certainly with respect, well, really with respect to all four witnesses, all the testimony lined up in terms of the times that the victims said that they were out of their offices, lined up almost exactly with the date and timestamps on the video. So for example, if someone said, I left my office at 12:30 and I returned around 1, you would see defendant arriving in the area, entering the office, and leaving within that exact time frame. So I think it was fair for the court to rely, as Your Honor pointed out, not as a foundation, but to support the inference of the accuracy of the date and time stamps.
What about the dwelling? What about the issue with regard to the dwelling?
I think the dwelling issue is very straightforward. I think it's solely controlled by this court's decisions in Ortiz and Harris. In Ortiz, this court expressly rejected the argument the defendant is making here, which is that the people were required to prove that each location defendant entered was a dwelling. And perhaps not coincidentally, Ortiz also involved the Columbia University Medical Center. I think the buildings were the...
But it's a different building. I mean, here, the problem is that accessibility is an important factor. And the places where the patients are housed are not anywhere near, I think it was the PNS building. I mean, they have to go downstairs. They have to go at least 1 block in one direction and essentially what's effectively 2 blocks in another building. That's not, that's not a, you know, accessible.
I disagree with Your Honor to the extent that I don't think the record supports any notion of traveling blocks. With respect to, Pena testified that with respect to the Presbyterian Hospital building and the Black building, one could arrive at the so-called lodging areas, the emergency rooms and other areas of the hospital where patients slept overnight within a matter of minutes. One instance, it would take 5 minutes because you would have to get down to the main floor and perhaps walk over to the adjacent building. But all the buildings were interconnected, so you could...
That's the point, I guess. So I think in our previous case law, when we found that it was a dwelling, that dwelling was within the building, within that particular structure. And it appears what you're arguing here is that Columbia University is comprised of several structures, and as a whole, it becomes a dwelling.
Well, that's exactly what this court found in Ortiz. I don't think the circumstances are really any different. And if I may, in terms of the accessibility issue, this case is, it was easily, even if you just look at the physicians and surgeons building, so you had 2 floors there, the 3rd floor and the 17th floor. Obviously, the 3rd floor is only 2 floors above the 1st floor where the various emergency rooms are located. So there's no question that that's inaccessible or remote. The 17th floor, however, again, the defendant could have taken an elevator down to he could have taken an elevator to the 8th floor, walked 1 or 2 buildings over and arrived at the sleep apnea clinic, which was also on the 8th
That's the
floor.
point, counsel. You have to walk over 1 or 2 buildings. In fact, I think that some of the testimony, the evidence was that it was the equivalent of a city block.
I don't remember that, Your Honor. I'm not disputing it. I just don't actually remember it. But again, I think...
So let's assume that that is the case, that they had to walk 5 to 6 minutes, the equivalent of a city block, to get to this other building. Are you saying that that suffices to make the building where this occurred a dwelling?
I think it absolutely does, because again, unlike Joseph, where there was a clear barrier between the area which the defendant entered. I think Joseph involved a bodega, and as many of these cases tend to do. And so there was a clear barrier between the basement of the bodega and the residential areas, or the residential apartments above the bodega. There was no such barrier here.
But in that case, it was still within one physical building, whereas this is not really one physical building. It's a building connected by a long passageway equivalent to a city block to get to another building.
I can only quote this court's decision in Ortiz, where the court found that the hospital, meaning the CUMC, was a dwelling, notwithstanding that the 4 locations the defendant entered unlawfully were not used for overnight lodging. That's precisely...
Well, but yes, we understand that, but the question is how far apart the
Well, I would commend Your Honor's attention.
where the taking occurred and where the sleeping occurs.
Right. I can't remember, I apologize, the exhibit number. It's either People's Exhibit 7 or 10, but there is a diagram, and I would encourage Your Honors to review that diagram. I think
that's your Exhibit 7.
Yes.
But I think that is a diagram that suggests that there's about a city block to the east, and then 1 or 2 blocks south to get to those buildings, to access those buildings. So these are individual buildings. I mean, whether you're walking on the street or even worse, as the defendant would have had to have done, within the maze of these buildings, it's not exactly accessible to reach to this idea of the dwelling where there are patients there.
I disagree that it's inaccessible because I think, again, a matter of simply...
It's not inaccessible, but the accessibility is not what is common in these other cases where it's easily accessible. This is not at all an easily accessible kind of thing, where you go up the one staircase and boom, there are hotel rooms.
To get from the 17th to the 18th floor, I imagine would be a matter of minutes on an elevator, and I think one would have to walk I can't remember if it's 1 or 2 buildings over to the Presbyterian Hospital building. I believe it's 2 buildings. I think I noted it somewhere in my brief. I apologize. I don't remember exactly now. Again, I contend that that is still accessible and not remote in the sense that the Court of Appeals had in mind in Joseph.
Thank you.
Thank you, Your Honor.
Your Honors, there's over 30 buildings on the Columbia University Medical Center campus.
We're not talking about 30. We're only talking about the other 2, I think.
I merely point that out to say that Ortiz deals with the Harkness Pavilion and the Presbyterian Hospital building. What we have here, there was no testimony at trial that any patients were lodged or kept their personal belongings within the footprint of the 4 walls and the roof.
But what about the fact that the buildings are connected? Is that sufficient to establish a dwelling?
No, Your Honor. The Court of Appeals has held that distance goes to accessibility. And here, the 6 areas that the prosecution identified at trial were so remote from the physicians and surgeons building and inaccessible by virtue of the Columbia University building size. To point to the Milstein Hospital, which is one of those buildings that has not come up yet, one would actually have to cross a major thoroughfare. As you can see on People's Exhibit 7, you would have to cross Fort Washington Drive to access that dwelling area. But we believe that the individual building of the physicians and surgeons building, that 4 walls and a roof, is itself a building. The statute doesn't permit, it is building singular, it doesn't permit for the amalgamation of over 30 buildings into one building for a dwelling purpose. This is just so far removed from the original night terror purpose of burglary that it's really just, even if you were to amalgamate them, this would fall clearly into the Astor House exception, which has been a part of New York burglary law for over 100 years and reaffirmed by the Court of Appeals in 2014. And the Astor House exception says that remote and accessible means that it is not a dwelling for burglary. Second, thank you, Your Honors.
Thank you. Did you say you were an intern?
Yes, I'm a student.
Yes. Very good job.
Thank you, Your Honor.
Hopefully you'll get an A. Thank you
Honor.
both. Walsh versus Wallace Law Office.
Good afternoon, may it please the court. My name is Jay Breakstone. I represent the plaintiff appellant, Jeffrey Walsh, and I have to add that if that's just an intern, maybe it's time to retire. What a fine job. What a fine job. The question presented here, Your Honors, is rather straightforward, and it involves Rule 1.5G of the rules that govern us all as attorneys. The question here is, if an attorney substitutes, or is substituted, excuse me, by another attorney, and...
Counsel, so we know the facts, and I want to ask you here, I think what you argue is that the doctrine of continuous representation tolls the statute of limitations, because I think there's no challenge that the statute of limitations expired. But where do you get the doctrine of continuous representation here, where there is a document that has been signed agreeing that one attorney's representation ended and another began?
The fact is that there cannot be a substitution in this state where the attorney continues to participate in the fee unless that attorney undertakes some responsibility. Now, there might be a question...
But do you have any evidence that, first of all, do you have any evidence that he was continuing to seek a fee? And second of all, what authority is there that they have to continue to, even if he was entitled to part of the fee, what precedent is there that requires that person still be liable for the purposes of malpractice?
We'll take, the first question is whether or not they were participating in the fee, and I'll address that. I think it's a given in this case that they were participating in the fee.
I'm sorry, I don't understand what it means to be a given. Is there any evidence?
I believe in the record there is evidence and a discussion of participating in the fee, but my adversary and my colleague can respond to that, and if I'm wrong, the case changes, does it
Well, no,
not?
I was hoping you could tell me what in the record supports your statement. So you can't tell me that right now, is that correct?
Well, the fact is, Your Honor, that in the record, the discussion with the court always assumes that that's the case, and I point in the record to, just a moment, Your Honor. Unlike that young intern, I need these now. Yes, in the record, Your Honors, if you go to page 27 of the record, you'll see the discussion with the court and the attorney from my office saying, I'm saying that based on discovery, that may be the case. And it goes, if there is a referral arrangement, then the Walsh firm, in exchange for a monetary interest in the ultimate outcome of the case, the Walsh law firm agrees to have continuing responsibility to the plaintiff. Now, that statement is made...
You're leaving out that the attorney said that may be the case if there is a referral arrangement. That doesn't affirmatively state that there is such an arrangement, correct?
And Your Honor, that's exactly the problem, because we had no discovery in this case. We don't know if that's true, and I suggest that if it were not true, that there was no monetary relationship, then it would have been brought out in the motion papers, because that would have been the true deus ex machina coming out of the sky and saving the other side of this question from being in front of this court. But the fact is that we had no discovery. And the fact is that statement wasn't opposed. And the fact is that it's only through that discovery that plaintiff would have been able to make out this case. But the judge below, in what he called, let's make this simple, just got rid of the case. No discovery, no question, left it open under whether under 1.5 the attorney was participating in the fee. And the reason for that was simple, because if the attorney was participating in the fee, he would continue to be responsible.
Thank you.
Very well, Your Honor. Thank you.
Thank you.
May it please the court, Anthony Green on behalf of the respondents here.
Counsel, let's assume, for the purposes of my question, that there was some sort of fee arrangement, whether it's for past services, future services. Is that sufficient in itself to say that there's a continuing, developing, dependent relationship between the parties?
No, it's not, because it's not a continuous representation. It's not a continuous provision of legal advice. What that might mean if it existed, and again, this doesn't appear anywhere in the record. It's not even alleged in the complaint. It's only through a counsel's affirmation, not even through his client's affidavit. All it means is that there could be a future fee dispute. And the Court of Appeals has said that fee disputes do not implicate the continuous representation toll. So there is no way that that could overcome the wealth of law that upon execution of a consent to change attorney form, that cuts off the continuous representation doctrine. And I would also say in the complaint, the plaintiff does not allege the provision of continued legal services after that point. The plaintiff also can't allege that there was a mutual understanding for a need for continued services because he executed the consent to a changed attorney. My clients couldn't say, well, you may have done that, but whether you like it or not, we're going to keep being your attorneys. that's just not possible, and my clients have never claimed that existed. There's simply no evidence in the record to support this speculation, and there's no reason to overturn the trial court's order.
Thank you.
All right, thank you.
Your Honor, by the way, when I refer to the joint responsibility, it's 1.5G1, which is the specific subsection that requires if you have a fee, you have joint responsibility. And
But counsel, go ahead.
But how do you square that with the allegations in the complaint that paragraphs at page 47 of the record that Ms. Wallace represented plaintiff until March 21, 2017, and after that point, defendants Leave and Steinberg took over the representation. There's no allegation of joint responsibility or anything else. Your complaint is very clear that there was one attorney and then there was another attorney. I don't understand how you can now, I'm baffled by how you now argue something quite different.
Your Honor, it's not necessary to make the allegation. One doesn't have to allege all the disciplinary rules and all the rules of professional conduct to make them apply. The fact is that if there is that substitution, there is a continuing responsibility. Now,
And what authority do you have for that?
1.5G1.
Is there any case law that says that that applies to that situation?
Which situation, Your Honor? I'm sorry.
To continuous representation, sir.
Yes. Well, it does apply in the sense of, I mean, you can take a case like Marin, which I argued in this court and went to the Court of Appeals, that talks about that joint responsibility in the 1.5G. And I can find, and the judge could find no case that says that that rule doesn't mean exactly what it says.
But do you have any case law that says that where there's been a substitution, that constitutes a joint responsibility?
If Your Honors take a look at Samuel v. Druckmann and Sinnell, a well-cited case at 12 New York 3rd 205 and cited in our reply brief at page 2, it talks about the prior 2107A2. There has never been in this state any substitution statute which allows for anything less than joint responsibility when there is a joint fee. And all we wanted was discovery here to be able to find out if the outgoing attorney continues to participate in the fee. And if that was true, and we were entitled to that discovery, if that is true, then Your Honor's question would be answered. Because continuing to participate in the fee means continuing to have responsibility to the plaintiff. And by the way, and in addition, and this came out in Marin, that not only are you required to have that joint responsibility, but you are required to reveal to the client that you're participating in the fee.
Thank you.
That also did not occur here. Thank you, Your Honors.
Thank you. B. Destiny.
May it please the court, Rebecca Viscatus for ACS. The evidence in this case established that the father's violence was so pervasive in his daughter Destiny's life that at 9 years old, she defined a lie as if my father said he didn't hit women. In dismissing the neglect petition against him, the family court ignored the father's pattern of committing domestic violence in front of Destiny and the clear effect it had on her.
What incidents are you relying upon that you say were established of domestic violence?
Sure. Well, beginning when Destiny was an infant, the incidents involving her mother, which her mother testified to.
When she was 3 years old, I think, right?
Yes, some when she was an infant, some when she was a toddler. Then her own reports of the father's continuing violence against another romantic partner.
This is the stabbing now you're referring to?
As well as
Was the stabbing established, for example?
The stabbing was established through Destiny's out-of-court statement.
Were there records? I would imagine that there'd be medical records. If a woman is stabbed, taken to a hospital, there'd be medical records. Were those produced?
Those were not produced. However, the family court referenced this and seemed to be looking for that in particular. However, the father and his then wife, Veronica, never said any hospitals that she visited around that time.
But all of that could have been discovered. All of those things could have been discovered. And Veronica says that didn't happen. I was suffering from whatever the ailment is, she said. Perhaps the child confused that I was complaining or in pain because of something else. And didn't the judge hear all of this, consider the credibility of the witnesses, the testimony and the time factor of how long these incidents they had transpired, and wasn't the judge in the best position to make those credibility determinations?
Sure, and the court did make credibility determinations, but that's not what the decision shows that the dismissal of the petition was based on. The dismissal of the petition was based on the court's determination that Destiny's out-of-court statements were not corroborated, which was a failure to consider the evidence as a whole.
There's credibility that goes into that. I mean, the judge is weighing what was stated by each witness. That goes to corroboration, doesn't it?
Yes, but the judge never really got to the point where the court was weighing the credibility of the father and Veronica against the incidents reported by Destiny, because the court said that Destiny's statements were not corroborated and essentially stopped there. The court's credibility...
That's not true, right? The father and Veronica both denied that incident. So they have the denial from the two individuals that were allegedly a part of the incident, and then you have no corroboration on part of the child. And something as serious as a stabbing, you would suspect that there would be medical records. Was there a prosecution? There's just nothing to corroborate that statement.
Again, the fact that Veronica at this point was denying that it happened would mean that...
When you say at this point, are you insinuating that at some other point she had a different story?
No, I'm insinuating exactly the opposite, Your Honor, that the fact that she was denying that it happened in this proceeding would suggest that if it did happen, she would have denied it at the time as well, that she would not...
Well, you can't deny a stab wound at an emergency room, right?
Right, but you could avoid explaining how it happened. You could avoid saying that your fiancé was the one who did it, knowing that you would not want to get him in
this is
trouble.
pure speculation. She said that she had an ailment and that was what caused it. All of these things, stab wound versus what she said she had, those things could have been determined, couldn't they?
It would be very difficult to without her cooperation. Essentially, you would have to subpoena records from every hospital in the city for an extensive time period, because as a 9-year-old girl, Destiny was not able to give an exact date and time when this had happened. She was able to
Well, we know they were together married for a year, together for 3 years. I mean, that could have been narrowed down, I think.
Right.
And it happened in a restaurant, correct?
The stabbing did not happen in the restaurant. The stabbing happened after they returned home. They had been at a restaurant, which Veronica confirmed was an outing that they had done, and then they began arguing there, returned home, and that is where Destiny saw her father stab his fiancée. This was an incident that Destiny...
But I still am baffled by, I don't understand what you say constitutes corroboration of the child's statement about the stabbing. And in the absence of that, we have a problem, right?
There would be a problem, but as this court has held repeatedly, evidence of similar prior actions can sufficiently corroborate a child's out-of-court statements about recent actions, and that evidence can be in the form of testimony from another witness in the family court proceeding. This court has held that repeatedly in sexual assault cases or sexual abuse cases where an older sibling testifies for the first time that this happened to them.
Those are situations where one incident of sexual abuse corroborates another incident of sexual abuse. Here you're saying that any prior incident of domestic violence can corroborate a child's allegation of a stabbing. Is that correct?
I think that the testimony
I don't think that the case law supports that, counsel.
I
There has
think,
to be some similarity between the incidents.
yes, that the father was subjecting his romantic partners to acts of violence in front of a young child.
Thank you.
Thank you.
Good afternoon. I'm Marcia Egger. I'm an attorney on appeal for Destiny B., whose case whose allegations this case relies on, as corroborated by evidence that her father was prone to use of domestic violence.
Counsel, are you substituting judgment, or are you representing the position that that the child has in this case?
Yes.
Which one?
Oh, the
Are you
latter.
substituting judgment, or are you
No.
advocating for the child's position?
Yes, the latter, the child's position.
Okay, you didn't file an appeal here. You're just,
No, we also
you
filed an
did,
appeal.
okay, all right.
So there are two appellants.
Right, okay, I just wanted to make sure.
Right. There's a habitual pattern of domestic violence that her mother attested to, which there doesn't have to be corroboration of every particular of the...
So isn't it right that aside from the one instance where it's alleged that the father threw the mother out, and only with underwear into the hallway, aside from that, the mother didn't testify that the child was present during any of those other instances, is that right?
She was present for one, it's clear she was, I think the evidence showed she was present for the incident in which the father threw the mother out of the house.
So that was when the child was 3 years old, correct?
Right.
So that was about 6 years ago, is that correct?
Well, at the time
was 9?
She was 9 at the time.
Right, so 6 years ago from the hearing. Isn't that rather remote, that one incident, to say that there's a continuous pattern of
But the
domestic
mother
violence?
testified to other incidents during a pretty constant pattern of domestic violence.
But this is,
Go ahead.
I mean, the child was being...
But as to those other incidents, there's no evidence that the child was present, correct?
I believe she was, the mother said she was, for one of them, she was 6 months old or 9 months old, something like that.
That was 8 years before the petition was filed.
8 years before
The petition was filed.
the petition was filed, right. But there's a pattern that supports that her current...
Counsel, even if we were to accept that there is a pattern of domestic,
what?
even if we were to accept that there was a pattern of domestic violence, the issue here is the presence of the child and the physical or emotional impairment or the imminent danger thereof to the child, right? How is that established from what we're going to assume is a pattern of domestic violence in which the child is not present for?
She was present for...
Just one, we've established
The
that.
one
Other than
there,
that, what else?
And she was around when the father had these incidents with, she said, with a former girlfriend.
You're referring to the stabbing?
Say what?
You're referring to the stabbing?
No, a former girlfriend that she said, Lucy, I believe her name is, that she had witnessed the father. A girlfriend that he'd had 2 years prior to the current situation. And that and she was present for these other incidents that she alleged. The one with the stabbing, and another one where her father was acted violently towards somebody who cut him off while he was driving. And she saw this as, she was frightened by his propensity.
but that's not domestic violence, right?
Excuse me?
That's not DV. That's not domestic violence.
No, but just that
He may be a violent guy.
she was frightened by all of these instances where her father's rage was taking the
Thank you.
form of harming people or seeking to harm people.
Thank you. You have a minute rebuttal.
Your Honors, may it please the Court. My name is Nicole Velasquez from the Bronx Defenders, and I am counsel for the respondent, Father Juan B. The Court should affirm the family court's dismissal of the neglect petition on two main bases. First, a lack of corroboration, where it should be expected that there would be corroboration if the alleged events actually occurred. And second,
What events were corroborated? When the child was 3 years old, that was corroborated by the mother, correct?
I would argue that that's not corroboration, Your Honor. I believe that the way that the allegations unfolded in this case are incredibly suspicious. For example, first there was an ACS investigation against the mother for allowing a sex offender around her children and acts that unfolded therefrom. And there was an initial conversation with Destiny on that first opening of that investigation against her mother, and Destiny reported none of this. She was explicitly asked privately, "What's your relationship with your father?" And her response was, "I don't really have that much of a relationship with him. I see him from time to time," and that was the end of the conversation. Then a week later, after the mother had time to pull together a story, suddenly it's the mother, at the mother's prompting, where she calls ACS and says, "My daughter has something to tell you about her father. You should question her." That then suddenly Destiny tells these stories. And so given that, given the timing and the way that these unfolded, I say that this is very suspicious, and that it perhaps has been, the underwear story, was something that Destiny perhaps heard from her mother, was told from her mother, and that's the basis for why she repeated it. And then, every story that Destiny then continued to tell about her father from there on grew more and more elaborate than the last and was unsupported by the record. And I further repeat that the allegations by the mother are simply not true and are not credible. They are very remote in time. The influence of her mother is very significant here. The motive and bias is real, and it worked. The ACS investigation that began against the mother suddenly concluded. We don't hear very much in the record about what happened from that investigation or how far it went, but within a matter of 1 week, it became an open investigation that focused only on Juan B. And Mr. B here denies all of these allegations and all of these claims. There's no other sources corroborating the mother's story. If you're going to be...
How do you respond to your adversary's position that there's a pattern of domestic violence here? And in addition to what we've spoken to already, there were also two domestic incident reports, one in 2009 against the mother and one in 2015 against Veronica.
That is not in the record, actually, Your Honor, that there were any domestic incidents reports, and that's precisely part of the issue here. This is a matter where there would be records. There would be police records. There would be an ACS case record. There would be hospital records. If this child witnessed a stabbing in the stomach where they dropped that person off at a hospital, she would have told the teacher. She would have told friends. She would have told guidance counselors. I would imagine that any mother hearing that would call 911, would call the caseworker who is actively investigating the case in a panic and say, "This happened," not say, "You need to question my daughter further about what her father has done with her." Also, additionally, these two parents were involved in custody proceedings. Domestic violence is weighed very heavily in custody proceedings, and none of that was raised. None of this supposed history that the mother testifies to was ever raised as part of those custody proceedings. When did it first
Is that in the record, counsel?
Yes, Your Honor. Both one of the appellants addressed it. I believe it was Ms. Egger's brief, and then it was also cited in my record as well, that the family first engaged in custody proceedings in 2016, and then there was the open investigation against the mother in September, I believe 13 of 2018. Then a week later, this suspicious phone call from the mother to the caseworker, and then 3 days after that, she then goes to court and files a modification of the custody and visitation order, citing an amorphous child neglect as the basis for that. And again, this is a situation where if I'm hearing that my daughter is witnessing a stabbing, I'm running down to family court immediately and getting an order of protection, there is no way that any of this would occur. And furthermore, the remainder of the mother's allegations are really amorphous in where Destiny was. Was she present? Did she know? And there's none of that here in the record, Your Honor.
Thank you.
Your Honors, just to respond to the arguments about the mother's credibility, the court did not discredit the mother's testimony about her own experiences with the father's violence. What the family court found after seeing and hearing the witnesses herself was that all of the witnesses were at times self-serving, but were also credible at times. And the court did not find that the mother had fabricated the father's violence against her, but instead focused on the fact that those events viewed in isolation were too remote based on the family court's evaluation to...
So again, what incidents were confirmed with the child present of incidents of domestic violence? You have the stabbing, you have the child when the child was 3 years old and maybe 6 months old, right?
Yes, there was one specific incident that...
So would you agree that what occurred when the child was 3 years old and 6 months old is rather remote in time to this petition?
If those were the only events in the petition.
Well, but those are the only ones, frankly, that appear to have some corroboration, right?
Only if this court also disavows the fact that prior similar acts can corroborate similar acts that occur in the future.
So throwing the mother out undressed is similar to stabbing the fiancé.
Yes, it shows a pattern of the father exercising power and control over his romantic partners in front of his young daughter with no concern for her health or safety. This pattern clearly influenced Destiny. She described her father as a violent man. She described being distraught when she did see him stab his fiancée, and she described being afraid when she saw his violence in other contexts, in the road rage incident that she also described.
Counsel, is it your position that if a petition alleges one incident within the last 3 years that's not corroborated, that it can be corroborated by incidents that are 6 or 8 years before that?
When it is in this context where it wasn't just that incident, that Destiny was describing...
Counsel, I'd really like you to answer my question.
But
are you saying that a single uncorroborated incident within, say, 2 or 3 years of when a petition is brought can be corroborated by incidents that occurred 6 or 8 years before that?
In the facts of this petition,
No,
yes.
I'm not asking. I'm asking you to answer my question.
Then yes.
And is there any support for that in the case law?
Yes, the cases that this court has decided where a parent's prior actions corroborate the actions at issue in the petition.
Thank you.
Family court relied on a second department case to disregard the prior history, but this court has ruled differently, and so has the second department in a more recent case. In Isaiah Keith B. and matter of AP, both from this court, prior incidents reported of a parent's misconduct by an older child were used to corroborate the allegations of the child about whom a current case was being brought. So that shows that there's some value. There's value to those, to the evidentiary value to prior events that happened before, even to a different child. In this case, I wanted to bring up that the stabbing incident may have not been as serious, and if the Veronica B. had not been admitted to the hospital for it,
Okay, now
Besides-
we're just completely speculating.
Yes, but it's
I
just as
thank you.
much, right.
for your
But it's speculation to
Yes.
say also that this is involved with the, that this was precipitated by disagreement between the parents about visitation.
Okay, but we're not, we're considering the fact that there is absolutely no corroboration for the stabbing when there could have been. Thank you all. Gonzalez versus 1436 Beach Realty.
Good afternoon, Your Honors. My name is Marie Hodukovich. I represent the defendant, appellant, respondent, Beach Realty. This post-trial appeal involves two separate areas. I'd like to do the liability first.
So, Counselor, there's a verdict. It appears to be an inconsistency. Why didn't the trial attorney at that time ask the judge to have the jury reconsider and resolve that inconsistency?
What happened was the judge immediately discharged the jury after they rendered the verdict. He said, okay, you're free to go, goodbye. And then he entertained the attorney's motion. So the judge actually released the jury first.
Wait a minute. At least the last time I tried a case, the jury announced the verdict in court, and the attorneys are following along on the interrogatories, and it would seem to me that it was pretty apparent at that time that there was a inconsistency in the verdict, no?
Yes, Your Honor.
So at that time, why didn't defense counsel get up and say there was an inconsistency?
The way I read the transcript is that the judge immediately discharged the jury before counsel had an opportunity to stand up, and that applies to both defense counsel and plaintiff's counsel. The jury was gone. He said, thank you for your verdict. You can go now. And after the jury left the room, that's when he began to entertain the motions. And I'm going to look for that page, if I might. But
so you all, okay, did you? You also have an issue with regard to liability. Do you want to address that?
I would, Your Honor. If I can just say, it's on page 649, just in answer to the first question. The judge says, on behalf of the court system, the jury is polled, on behalf of the court system, you're free to go. You're now free to talk to whomever you want. The jury exits the room.
I just don't, I mean, look,
So
you know,
yes,
I
Your
just
Honor,
don't
on
understand,
liability-
even if a judge says that, someone doesn't say, may we approach the bench? I mean, it doesn't take much to do that. Or the jury is in the room, the last person's out, may we approach the bench before they go? I don't understand all of this, the judge let him out right away. I don't see really how that, you know, answers the question as to why that would thwart an attorney from.
I understand the court's point that that's how the record reads, and that's the situation
Maybe we
that
should
we're in
move
with
on to
both sides.
Thank
So
you.
for liability, this is a slip and fall on a substance on the stairs. The plaintiff entered the building at 11 a.m. She saw some wetness on some stairs. She avoided it. It was about at the top of
How do you deal with the porter?
The
porter's testimony that is equivocal because he says he cleaned the stairs or he went up and down the stairs, but he's equivocal as to whether there was anything on the stairs.
I don't think he was that equivocal, Your Honor. He said he went through the building at 9 o'clock. He didn't remember anything about being on the stairs. It was his
Doesn't he
custom and
say he
practice
wasn't
to go through
sure?
there.
I mean, I'm not
And then
sure what, he says he's not, I don't know, he says he says he wasn't sure about whether he noticed any unsafe condition on the stairs in the morning.
And then I believe he...
Did you not hear what I said?
Yes, Your Honor.
So I'm asking you, is that not equivocal? That statement, the way he said it?
Because I think that his next statement was, I'm not sure, I don't recall so, or I don't believe so. He had a second comment.
So it's credibility, right? Plaintiff says before she came 3 hours earlier, she saw a wet spot. The porter testified what he testified. Jury hears that, balances, and makes a determination. Why should that determination be changed at this point?
I think that I just, again, want to emphasize that I don't think that testimony of the porters is sufficient to say that the condition existed at 9 a.m. But let's even take that point, because I was prepared to say that the condition at first existed at 11. Even if it existed at 9 and nobody had inspected it, under the case law, there's not a duty to have a 24-hour inspection. This is Christmas Day and a holiday. The plaintiff, if it existed at 9 a.m. and the plaintiff fell at 2 p.m., I have cases, a number of New York City Housing Authority cases that say that that kind of a situation, 21 hours, 12 hours, 6 hours, 3 to 4 hours, those times of time periods are not enough in a residential situation to provide notice, constructive notice to the defendant. So, and the plaintiff never distinguished any of my constructive notice cases under the Housing Authority. All the plaintiff's cases are about public areas, grocery stores, subway areas, and that kind of thing. They're not directly on point as are mine. And I see that I'm out of time already, and thank you for your time.
You have rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff, respondent, appellant. Judge Singh and Judge Renwick, to your point, someone should have said something. If you look at 649 to 650, someone should have said there was an inconsistency. No lawyer did, but you could have done it. And you're right. All you had to say was, wait, before you discharge the jury, there's an inconsistency, let us talk to you. It didn't
So
happen.
how do you reconcile, at this point, how do we reconcile the inconsistency?
It's simple. You decided a case that I was actually on, Scott against Possis. It's in the brief. What happened in Scott was there was an inconsistency in the verdict. There was no motion to cure the inconsistency. And this court said, citing to a trilogy of cases, including Paucay, P-A-U-C-A-Y, and a case called Natoli, which is subsequent, that even where there is a waiver of a claim of inconsistency, the jury verdict can be against the credibility of the evidence and material deviation from reasonable compensation. And in Scott against Postis, when you look at the briefs, what happened there was a substantial award for future medical expenses, 0 award for future pain and suffering, just like here. So our argument isn't that under Greziak and Barry against Manglass it was properly preserved. It clearly wasn't. I can't stand up here and say it was preserved. But it is definitely a material deviation from reasonable compensation and a verdict that isn't supported by credibility of the evidence.
So the remedy is a remand?
Well, what I would like you to do is only remand on the issue of pain and suffering. That's what I'm aggrieved by. I wouldn't want you to, do the entire trial again. And as you know, there's this old United States Supreme Court case called Gasoline Co. against Champlain, which says if things are decided properly, you don't have to have a retrial because there's one error. If I can, Judge Renwick, you pointed out what a witness said. It's on page 168, and I think it's directly on point. He says, this is 168 line 17, question, I'm not very sure, but I don't think that there was. I also think that the cases that my adversary says that states that are directly on point or not directly on point, if you look at the cases, they're mostly municipal cases. In 3 of the cases that she cites, this court specifically said that it would be inappropriate for the appellate division to tell a municipal defendant, not a private defendant, that there was a certain cleaning that was supposed to be done. In one of the cases, in fact, you're dealing with a cleaner who does nothing but clean. Remember, we have a different fact pattern here. We have one superintendent for 2 buildings. And when you look at his duties, he doesn't seem to have a lot of duties. And there is a case decided in 1996 called Cavani, 232 AD 2nd, 284, dealing with a private landlord where you said this, and I'm quoting, given that defendant employed 2 building maintenance people at the time, it cannot be said as a matter of law that 90 minutes was an insufficient time to allow for the correction of a defect that was visible and apparent. Here you have one superintendent for 2 buildings with a situation where the defect existed. Best case scenario for me, in the case where I'm a respondent, 3 hours. That's what it's, so this is just a pure question of fact. Can I just have 25 more seconds?
You can have 1 minute and 31 seconds.
I'm sorry.
But not more than that.
Okay, I forgot what the light was. The jury's award of $500,000 for the medical expenses is explicable. I know what the attorney said. The problem is the record here is just awful because we don't have a lot of the exhibits. What the lawyer said is it's a $262,350 expense because of comp. That's probably true. But the judge was imploring the parties to agree to a number. They didn't. The jury's decision was correct under the charge.
But the decision has to be based on the evidence, right? What's the evidence that supports that, that decision?
If you look at 605 to 606, although we don't have it, and that's one of my pet peeves, there were actual bills that aren't in this record, but that were at trial at $505,000. That was the amount. I understand that you can't get damages for what you have. I'm just saying that the jury's decision, when you look at the court's charge, was correct. And my last point is that the jury's award of $200,000 for the lost earnings, even though the plaintiff calculated it out at $189,000, is not infirm based on your decision in Rivera against Montefiore, where you said that where you're dealing with generic kinds of damages, a jury is not confined to the exact numbers given by the experts or given by the evidence. So if it was $500,000, I'd have a problem. But 10 years of past pain and suffering, right? 9 years elapsed from the time of the accident to the time of the trial. That seems to me the jury can say you get a little more money than just the amount you had.
Thank you.
Just a couple of points, Your Honors. Back to the notice issue, the super did have a custom and practice that he followed very, very strictly. He said he always inspected every building at 9 a.m., and that was his custom and practice. With respect to the future pain and suffering and the future medical, they based their claim for future pain and suffering on the award of future medical. And our position is not so much that it's an inconsistency, but that the future medical is also not supported by the record, that the plaintiff didn't have any treatment for her knee from 2011 on. She didn't have any treatment for her back from 2014 on. Her own surgeon...
But wasn't there testimony with respect to the onset of arthritis and the various ailments that you suffer as a result of traumatic injury, right? So couldn't that be a basis for an award of future damages?
Your Honor, there's no objective evidence that she did in fact have any post-traumatic arthritis. She had arthritis in her knee on the day of the accident. And although it was suspected that she might develop it, there's not a single x-ray, there's not a single medical record that said she had arthritis in her knee after the accident. And there's an MRI that the doctors testified to that in 2014, they didn't show a past fracture in the knee. With respect to the back, her own surgeon said she did fantastically. She did wonderful, excellent. He went on about this for several pages. On cross-examination, that was in his medical records. So instead of viewing this as an inconsistency case, we're urging you to look at it as a case where if they're hinging their future pain and suffering on an award of future medical, but the future medical is not supported, then the future, no award for future pain and suffering makes sense.
Oh, is the converse also true? If there's support for future medical expenses, there should be future pain and suffering?
That they have cited cases.
I'm just asking you, would the converse hold as true?
And I'm agreeing only that there are cases that say that if there's an award for future medical and that's sustained, and then there's no award for future pain and suffering, then those cases, I believe, are being remanded for trial for that future pain and suffering.
So you agree that at least with respect to that issue, there should be a remand?
I can't dispute the case law, Your Honor.
Okay.
I'm not going to do that.
Thank you.
Okay, thank you.
That's all right. I'm just going to be 15 seconds because I'm only allowed to talk about my cross appeal. I would just ask you to look at Scott against Postis on the inconsistency issue. I know that you raised the preservation issue. I think Scott's directly on point, and it cites to all of the 4 cases that I cited on how that award, even though not preserved, can't be sustained. And Judge Singh, again, I would just ask you to retain the rest of the awards because I think they're based on abundant evidence and disputed evidence. Thanks for listening.
Thank you both. People versus Maximo de la Cruz.
Good afternoon, Your Honors. May it please the court. My name is Cara Labini for Appellant Maximo de la Cruz.
Good afternoon. Counsel, your client has a justification defense, but he also says that this incident with the knife was an accident. So doesn't that position, that it was all an accident, refute the justification, any justification charge being given?
No, Your Honor, because in the justification analysis, we take the evidence in the light most favorable to the defendant, which in this case, within the justification analysis, should be that he disarmed Ms. Galvin of the knife, and then she grabbed the blade and he pulled it away from her and caused the injuries. And that account is consistent with the forensics and with the injuries themselves. So the court...
So what part of the accident aspect of it should we not give credence to? I mean, that was his position. This was all an accident.
Well, I think the word accident is equally applicable to a situation where he believed force was necessary, and a situation where it was, completely ad hoc and involved sort of no affirmative conduct of his own. So,
yes, okay. So then the pulling of the blade, as he says it, through her hand result in the blade going down to bone. Is that consistent with deadly force or with something lesser?
Well, the point is that it was a question for the jury and not for the court. It's not a question of law. And we know that because the court used two improper proxies for its analysis in this justification discussion. First, serious physical injury. The court found that as a matter of law, serious physical injury was caused. And yet it also charged assault to the jury, which merely required the finding of ordinary physical injury. So it is very reasonable that if only ordinary physical injury was caused, the causing of that injury only employed ordinary physical force. So it's, that analysis is wrong on process and it's wrong on result. On process, it's wrong because serious physical injury is simply not a proxy for the justification analysis. The justification analysis has to focus on the nature of the force used, not on the severity of the injury. Second, the court used the dangerous instrument as a proxy for the justification analysis, and we know under Vega that that's incorrect. This error was not harmless, again, because the...
Okay, I want you to address that. Why isn't there overwhelming evidence of guilt? There's an admission, correct, by the defendant that it was a mistake, and then there was the testimony of the victim. Why isn't that sufficient? And he had his story. Jury heard it.
Because there's no dispute here that there was a reasonable view of the evidence that only ordinary physical force was used to cause ordinary physical injury.
That would cut to the bone?
Yes. Well, the court found that because it charged assault to the jury. So by charging assault to, but depriving the jury of the question of whether ordinary physical force or deadly physical force was used, it predetermined one, but not the other. It's inconsistent and it's wrong. And that's why the court should reverse.
So you're saying it's inconsistent if you find that there was serious physical injury as opposed to ordinary injury?
I'm sorry, say that again?
You're saying that those two are mutually exclusive or inconsistent?
It's inconsistent to determine that serious physical injury was created as a matter of law, stripping that question from the jury in the justification analysis, but also asking the jury to find that serious physical injury was in fact caused, or giving them the choice of that or ordinary physical force under the assault to charge. Does that make sense?
You're saying that because the judge found that the facts were consistent with only serious physical injury, that they removed the issue from the jury?
So on the justification analysis, the question is whether serious physical injury was possible, right?
Right.
Was likely to occur. The court found that serious physical injury occurred as a matter of law, so therefore deprived.
Yes, so that's what I said, that you're saying that the judge found that and took the issue away from the jury. That's what you're saying.
Yes, but he did not do that on the assault to charging, because the assault to only requires that there was ordinary physical force caused. So he left the question for the jury on the assault too, but deprived the jury of it on the justification question.
Okay, thank you.
Thank you.
May it please the court, Molly Morgan on behalf of Respondent. The trial court properly declined to charge the jury on the ordinary force justification defense for 2 reasons. Initially, as Your Honor pointed out, defendant was not entitled to any justification charge at all. There's simply no testimony.
The counsel is saying that the judge took that issue away from the defendant on the serious physical injury, and therefore did not provide the question of justification on that issue. And then did not do that on the lesser issue with regard to ordinary care. Is there a problem in doing it that way? The judge's finding and sort of taking the issue away from the jury on the, I guess, the serious physical injury issue?
Right.
The justification with regard to that?
Yeah, there's no problem with that for 2 reasons. First, I think what defendant is trying to do here is say that the court found serious physical injury and therefore didn't decide that there was no reasonable view of the evidence that defendant used anything less than deadly force. But I think here, looking at the whole transcript, it's pretty clear that the court engaged in an analysis using not only the extent of the victim's injuries, but also the implement used and the way defendant used it. So the court used all of that to determine that there was no reasonable view of the evidence that defendant's conduct was anything less than deadly physical force. Another issue with that too is the court, in giving the lesser included, didn't have a choice but to submit all of the elements of the offense, of course, to the jury because those were the elements that the people had to prove. And I think defendant's argument falls flat because the Court of Appeals has rejected a pretty similar argument in a case, People versus Curtis, where the trial court had submitted a lesser included charge to the jury, but just because the trial court submitted that charge didn't entitle the defendant to another charge that related to that lesser included. It was entirely within the court's purview to submit only the deadly physical force justification defense because that's all that was conceivably supported by the evidence. And again, going back to my initial point, there really was no entitlement to any justification defense at all. Defendant pulled the knife out of the victim's hand. That's simply not a crime. Finally, I would suggest that even if any of the court's isolated statements would amount to error, there's no remedial action required here because, again, there's simply no reasonable view of the evidence that conduct was not readily capable of causing death or other serious physical injury. There were 2 other points in this appeal. Unless the panel has any further questions about any of those points, we request that this court affirm the judgment of conviction.
Thank you.
Thank you.
Respondent cites a case, People versus Curtis, is that right? I don't believe that was cited in their response, so I can't respond to it here, unfortunately. Do your honors have further questions on the justification point?
No, I don't think so.
Okay. On the sentence reduction, we ask that your honors reduce the sentence in the interest of justice. Mr. De La Cruz got 10 years here when the court before trial offered him 9. This is his first conviction, his very first arrest, and the testimony of Ms. Galvin, as well as her mother, Ms. Reyes, indicated that Mr. De La Cruz had never even so much as had a temper. This is not a violent person, and therefore we ask your honor to reduce the sentence.
Thank you. Thank you both. Commission versus Mark Greenberg Real Estate.
Good afternoon, Your
Ma'am, I
Honor.
understand that you're representing yourself, you're pro se, so you have 2 minutes to tell us what it is that you wish to tell us with regard to this case, what your position, what you'd like us to do in this case. Okay?
Okay. This appeal is about the error decision by Judge Getz in the lower court denying plaintiff motion for default judgment. And the demonstration of the evidence in the appendix will show that the defendants were all properly served in pursuant to Civil Practice Law Rules 3215 and 3082. And the clerk court, Honorable Milton Tingley, certified that they were all served, and the court received the documents. They were served on February 20, 2020, and an affidavit of service was filed on March 3rd. And it was by an individual, not a party to the case or have any interest. And in the reply brief, Exhibit A shows the 17 actions that was filed between the parties on this case, and it shows the list of the 3 affidavit of service on March 3rd. In addition, in the appendix, there is, on page 4, it shows the judge decision, and it shows Exhibit A to F, which shows the affidavit of service and certificate of mailing, and the attorney for IH Preservation Partners and David B. Hirschon chose to omit that Exhibit F didn't exist, which is the certificate of mailing showing the individuals were all served a 3rd time by mail. And on page 17, it shows that they were served individually and as a whole by the individual server, Mr. Shaw. I see I'm out of time.
Thank you. Do you have something else? I'll give you 30 seconds if you have something additional that you can fit into that time.
I ask that this court overturn the error decision and award the relief demanded in the summons, in the complaint, and any other
relief that we see fit. Okay.
Yes.
Thank you very much.
And this has taken such a toll on my health that I'm here now, barely any sleep, I can barely speak. I apologize.
We understood you. Thank you very much.
Thank you.
Manipal Education versus Tafeek.
Good afternoon, Your Honors, and may it please the court, James Hirschhorn for Manipal Education Americas. This is a case of a corrupt purchasing agent.
Counsel, do you have a problem on, with regard to the statute of limitations here and the fraud?
Well, the trial court certainly thought we did. We do not. The trial courts...
So the fraud began in 2010, I believe, right?
In 2010.
And there was, the case began in 2019, right?
2018.
2018? I thought it was 2019.
2018, 8 years.
Okay, either way, that's more than 6, right?
Yes, it is.
So that, they're in right there, that's more than the 6 years, but there is this, the issue with regard to whether or not, you know, the 2010 emails, and whether or not there might have been, you know, an inquiry notice or something.
I'll be happy to speak to that.
Okay.
First of all, the emails did not put us on notice at all. The
Why?
reason
Why is that?
The reason being this court's decision in TPL versus Helmsley Spear. Tafeek, our purchasing agent, is a fiduciary. He's required, if he has a conflicting interest, which he does, to make a full, complete, and candid disclosure.
Well, would that have been reasonable to rely on him when, you know, the email was so clear here?
Well, the email was not clear with respect, Your Honor. The email said, yes, I have an equity interest in exit, which is something.
Just that in itself, where an employee has an interest in another company and is giving business, isn't that in itself, and I know he says, I'm not getting monies from these deals, but isn't that in itself sufficient to put your client on some kind of inquiry notice that some steps should be taken to investigate the veracity of what's being said?
I suggest it's not, Your Honor, because he concealed by revealing. He says, I have an equity interest, which again is something he now denies. And what that means is he takes part in the profits of the company. If it charges a reasonable price and makes a profit, he gets paid below the line. What we are alleging in the complaint is that he was getting a 30% finder's fee, which is a fee off the top and which thereby adds 30% to the price of every contract.
Well, we understand, excuse me, counsel, we understand the allegation is that he took more than you expected him to take based on the emails. But didn't the emails in themselves suggest to someone in your organization that a 20-year-old who was making deals with a company in which he had an equity interest might require some more investigation by your company rather than just throwing contracts worth hundreds of thousands of dollars to them over the next 8 or 9 years?
I'll fall back.
And by the way, can I just add, I'm not sure if Justice Singh mentioned it, but it also said in those emails, it would probably be best to use a different company so there is no conflict of interest on my end. I mean, did anybody need more than that?
2 points with respect to that. The first.
Well, I'm just sort of tagging it along to Justice Gesmer's question.
Yes, with respect to both questions. The first is that, how shall I put this? The law is that we're not required to make further inquiries. That's TPL and the cases which follow it. That his obligation was to make a complete and full disclosure. My second point.
In other words, you could wait 20 years and you can go back 20.
No, we can't go back 20 years, Your Honor. We can only go back 6 years. This is my second.
Oh, okay. So are you conceding that you can only go back 6 years?
6 years from, we can go back under the
6 years from
statute.
the time you commence the
We
action.
can go back under the statute for the longer of 6 years from the date of the fraud or 2 years from discovery.
Wow.
Yes, and our alternative ground here is that at least the last 6 years of transactions before he left are within the statute, because that's the longer of 6 years, and that Yin Shing Lung is quite clear that if you have separate transactions, the statute.
So you're saying there was a
runs for each
continuing
one.
wrong that went after this 2010 email?
We're saying
there were other instances of that.
Yes, there was a sequence of wrongs from 2010 through 2018, and under Yin Shing Lung, each contract, each deal with exit was a separate exercise of discretion, and therefore the statute runs for that. If we assume that we were on some kind of inquiry notice, I submit that the reasonableness of the inquiry note, of whether or not we made inquiry, presents a question of fact that was inappropriate for summary judgment here. Because when you look at the record as a whole, particularly when you look at the Greenberg affidavit, Tafeek might have been 20 years old, but he was apparently a charming 20 years old. He closely cultivated a relationship with his superior. He was a frequent guest of his. He even was walked down the aisle by his superior at his wedding. He did everything he could to build up a relationship of trust. And whether or not we should have been more shrewd, we should have been more circumspect, we should have been, frankly, more suspicious, is not the kind of question that can be determined on summary judgment here.
Thank you.
If you have no further questions.
Yes, you have rebuttal.
May it please the court, Jordan Greenberger for Respondent Zane Tafeek. The court just hit the nail on the head. These 2010 emails couldn't be any more clear.
Well, counsel says that, you know, even if the 2010 emails did put him on inquiry notice, and that would have been 6 years before the action was brought, he still has continuing acts that he can look to that occurred within 2 years or whatever it was that he said of the time the action was brought. What about that?
A few responses to that, Your Honor. First, what else could my client have said that he didn't say? He said, I have a conflict of interest. You should pick somebody else, okay? So even the statute...
He could have been honest. He could have said, I'm getting 30%. No?
He says, I have a vested interest. He says, we should pick somebody else.
But what's reasonable about that is, yeah, I have an interest in the company, and so presumably I get profits. But I think it would be incumbent on an employee to disclose, in fact, that he's essentially getting a kickback.
Well, there is no evidence in the record that he was actually accepting a kickback at this time, or really any time. There's Mr. Greenberg's affidavit saying, I was told that by the other respondent. There is nothing in the record showing that. Let's say that it's true. Let's assume that he was getting 30%. First of all, the continuing wrong argument, they never raised it below, and they just raised it in their reply brief on this appeal. Secondly, my client, unlike the other respondent, has another defense, which is the release.
Oh, you're not seriously arguing that that release released your client, are you? It certainly released the plaintiff, but there's no language in that release, or I could not find any language in that release that released your client from claims. Could you show me what in that release releases your client?
Sure, Your Honor.
I mean, there's sort of precatory language about this is nice, but it doesn't actually release your client, does it?
Your Honor, respectfully, we disagree. Paragraph 2 is not a preamble. It's the second paragraph of the contract. And, you know, oftentimes you look at a contract and you can infer what the intent is. Here, the parties are actually telling you what the intent is. They're telling you the parties, which is defined as both my client and the employer, have entered into this agreement as a way of severing the employment relationship between them, and here, amicably settling any potential disputes concerning employees' employment with the company or termination from the company.
Right, but the operative paragraph, counsel, is paragraph 5, which has a detailed release which only goes in one direction.
Your Honor, obviously paragraph 5 is there. If you look at paragraph 2, that says additionally. The word additionally
But can I stop you there for a second? Sure. Doesn't also paragraph 2 say, quote, as more fully set forth below? And then that would refer the reader to paragraph 5, and as my colleague pointed out, the release goes one way?
So it does say, as more fully set forth below, about releasing.
What does that language mean?
We consider it belts and suspenders. Okay? The beginning of the paragraph says, we're resolving all disputes and the parties desire to resolve the above referenced dispute and all issues, blah, 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 without the further expenditure of time or the expense of contested litigation, which is why we're here. We obviously acknowledge paragraph 5, right? It's not uncommon for an employer to present their departing employee with a severance agreement with a broadly worded release that covers any possible thing under the sun having to do with age discrimination or sex discrimination or something like that. But what does the first 2 sentences mean if not we're settling any potential disputes?
Well, for one thing, you say they're settling any potential disputes arising from his employment, but it doesn't say they're settling any disputes arising from his stealing from the employer, which is really what you're saying that this would also do, right?
Well, the basis of their claim is a quote-unquote faithless servant doctrine, which assumes that he violated his duty as an employee. This whole thing has to do with his employment, the relationship between the employer and the employee. That's the basis of their claim.
Well, it's a breach of a fiduciary duty, which doesn't necessarily always arise in an employment context.
In this case, they're alleging faithless servant as the basis for the fiduciary duty. Otherwise, there's no other fiduciary relationship other than employer-employee. I just want to also address, if the court were to reverse, we have other arguments. They failed to plead with particularity. I see my time's out. Thank you, Your Honors.
Thank you. We have your brief.
Good afternoon. May it please the court, Carter Reich on behalf of respondents Tristan Konechsky and Exit Editorial, Inc. I just want to reiterate what my colleague said. Your Honor hit it on the head when he said the 2010 email chain was so clear, and I think the appellant has acknowledged that it was clear. When you cut through all the sound and fury in their briefs, the reality is that what they discovered shortly after Tafeek was fired in October of 2018 was the email that was in their possession all along. It was this institutional knowledge that they had for 9 years that they failed to act on. And to correct the appellant, the complaint was commenced in May of 2019, not 2018. And if there's any doubt about this, you know, the complaint alleges shortly after October 2018, they became aware of this pattern of self-dealing. And even in their reply brief, they said that it wasn't until that moment and that they acted quickly after. But we went through some discovery, some limited discovery prior to the motions. And in that discovery, we repeatedly pressed the appellant, what did you discover after October 2018? What documents evidence a partnership between Tafeek and my client? And their response was the 2010 email chain. So they can't stand before this court now and say that that is meaningless, it didn't clue them in, it didn't put them on inquiry notice, because that's the basis of their entire case here. And just to look at the timeline's very telling. In January of 2019, January 24th of 2019, my client goes to a meeting at the office of plaintiff's CEO, Neil Simon, who is an attorney, by the way, and asks, why am I not getting paid on my $126,000 of outstanding invoices? At that meeting, my client was threatened, intimidated, and he left there and said, I'm walking away from $126,000. This lawsuit followed 6 months later or 4 months later. And then the first time that Appellant even went and solicited bids for other work to see if my client's work was overinflated was November 6th of 2019. And that was something they could have done in 2010, 2011, 2012, at any time. We never prevented them from soliciting other bids. And the record even contains evidence that when the finance department, not when Mr. Tafeek, but when the finance department questioned invoices, we would accommodate them with a lower rate. So they knew they had the ability to negotiate rates. The Greenberg affidavit makes that clear, that they knew they could do it, and they did it on a couple of occasions. They're a very sophisticated entity. They're no stranger to litigation. They knew what the 2010 email exchange...
Is it unlawful to charge over market rates?
No, and they haven't presented any evidence of what market rate is. You know, one attorney charges $1,500 an hour, another charges $750 an hour. The more expensive attorney isn't defrauding his clients. And you know, the appellant goes on and on and on about how our argument is you shouldn't have trusted us. And that's not what we're saying. Is we're saying here's the price. In 2010, here's the price. We're not preventing you from going out and soliciting other bids. If you have an issue with the price, talk to us. We'll accommodate you. They never did that. And to force respondents to defend their acts from 10 years ago or 6 years ago even is just is insane at this point. So unless the panel has any other questions, respondents rest on their brief.
Thank you.
Thank you.
Counsel, could you?
I'm sorry, go ahead.
Could you address the question of your contract with Exit, I'm having trouble understanding how you claim they breached it, except that you claim they charged them more than they should have, but you agreed to that amount. So what is their breach?
The breach is that, we lay this out in our reply brief. It's a breach of the implied covenant of good faith and fair dealing.
Did you assert that, sir? Did you assert that in your complaint?
It's subsumed in a breach of contract claim. On page 22 of our reply brief are the cases that deal with that. It wouldn't have to be pleaded.
Do you raise that issue anywhere before your reply brief?
We did not raise it before. In our main brief, we argued that we had not waived the breach of contract claim, which was the argument presented below, because breach of contract, because waiver requires knowledge, and we had not been fully informed of the relationship.
Forget about waiver. What provision of the contract? I think that's what my colleague was getting to. What provision of the contract was breached here?
The provision of the contract that's breached, Your Honor, is that, how shall I put this?
Sometimes it's difficult to find a way to put
the hen house. This was not an arm's length agreement with respect to price. This was a price that was negotiated by a corrupted agent.
But what was stopping you from going and getting another price from some other agent, some other company?
The answer to that, Your Honor, is first of all, you are correct that nothing was stopping us except our trust in our agent.
But why does that run as against Exit? I mean, they didn't state in your contract that this is the market price, this is not an inflated price, this is the best deal you could get. It's the deal they negotiated with you. Why is that a breach of contract?
Except they did not negotiate it with us. They negotiated it with themselves because the person they were negotiating with was on their payroll. Was getting 30% off the top.
But you knew that. Not the 30% on top, but you knew he had an equity interest back in 2010.
Correct. We knew he told us he had an equity interest, which he now denies ever having had.
So it sounds like all of your issues are with Tafeek. Did I say that right? Tafeek, but not with Exit.
Would you please repeat the question, Your Honor?
I said, so it sounds like all of your issues are with Tafeek, not with Exit.
No, they are not with Tafeek alone. The reason they're with Exit is twofold. First of all, there's the contract claim we've been discussing. And second of all, we plead that Exit was a knowing aider and abetting of Tafeek's breach of fiduciary duty because the fact that they were paying him in cash is circumstantial evidence of guilty knowledge. Honest people do not make cash payments to a customer's purchasing agent.
Thank you.
Thank you, Your Honor.
People versus Thomas Gregory.
Good afternoon. My name is Elizabeth Vasily, and I represent Appellant Mr. Thomas Gregory. May it please the court. The complainant, police officer John, barely suffered any injuries at all, let alone those amounting to substantial pain as required to establish physical injury for a second-degree assault conviction.
But you have a low threshold here. I mean, there's a low threshold for physical injury and substantial pain, as long as it's not petty slaps. And she testifies that she had pain, she had swelling, she had scratches, she had contusions, she suffered multiple punches, she was elbowed, she was punched in the face and elbowed in the stomach, abdomen area. Significant, I mean, it was significant enough that they had to do a CAT scan, I think it was, to rule out that there was something more serious. She went in with a level 7. I understand that she came out with a level 2 and she had an ice pack, but why doesn't all of that amount to substantial pain? I mean, emergency rooms, whether it's a police officer or not, don't just do CAT scans for the heck of it.
The CAT scan results did come back normal, Your Honor. She also never took
I know
Tylenol
they
or
came back normal. It's the fact that her complaints were so serious that they had to do one in the first place.
That's not in testimony, Your Honor. It's nothing in the record that say that CAT scans are more serious by any means, or that
I understand there's nothing in the record, but it's not like they give out, CAT scans like Band-Aids. Hospitals don't just do CAT scans for the sake of it.
the results came back normal, and she didn't take Tylenol, she didn't take Advil, she didn't miss work. All of these factors go into the ultimate conclusion that she didn't suffer substantial pain. She also never testified that the pain lasted more than a couple hours. In court, she never even said the pain was severe. She merely just said she had pain, period. And this court has held time and time again that generalized statements of pain without clarifications, without saying it's severe, without lasting even more than 2 days is insufficient for physical injury. She did only receive ice at the hospital. She never said that the pain was throbbing, was particularly intense. And that's just, the case law is clear that in cases where the pain doesn't last more than 2 days, that's not enough for.
You're saying there's a minimum threshold of 2 days for substantial pain?
Yes, Your Honor, there's courts that have said that because the pain didn't last more than 2 days, that was insufficient. Because the pain, although was severe at the beginning, didn't last more, only intensified a week later, that's been insufficient. And a stubbed toe is fleetingly painful. That's probably a 10, but if that goes away in a number of hours, that's not what.
Counsel, a stubbed toe is not the equivalent of being repeatedly punched by someone, elbowed, that is considerably bigger than the officer, right? I mean, you're not equating the two, are you?
The facts of what actually happened in the assault are not considered in the analysis. That's not the test. The test is not how many times someone was punched.
Well, you can't consider the intent of the defendant that's delivering the blows in terms of injury?
You could consider whether there's specific intent to injure the person, but in this case, Your Honor, there isn't any of that in the record. There's cases where a baseball bat.
The defendant was trying to flee, and he removed the tasers and then punched the officer twice and then fled. So clearly the punches were in an effort to disable the officer so that he could flee. So that there was an intent there, certainly to inflict injury serious enough so that the officer wouldn't be able to do her job and detain him.
Although that can be considered, Chittick makes clear that the most important factors are objective evidence and
yes,
subjective
they are the
evidence.
most, but
And the
I think
photographs.
what my colleague did was suggest that those factors are also influential. Not that they're the most, but that they are also to be taken into consideration.
The evidence in the record indicates that Mr. Gregory was trying to run away. It does not indicate that his intent was to cause substantial pain to the officer. I think if it was.
So there weren't multiple punches to the body, the face, to the neck areas, which resulted in medical intervention?
There were multiple punches, but that's not the test, Your Honor. The test is not what the conduct was. There's even a case where a baseball bat was used to hit someone, which is a weapon, but that case didn't amount to substantial pain because the pain didn't last longer than a few days.
Thank you.
Your Honors, and may it please the court, Anna Notchik for the people.
Is there a 2-day threshold for substantial pain?
A 2-day threshold. While this court has held in the past that 2 days was not enough, there is no minimum threshold of how long pain has to last in order to prove substantial pain.
So was there substantial pain here where after a couple of hours, the officer was able to leave and had only a level 2? I mean, expressed only a level 2 of pain?
Yes, Your Honor, because when she initially got to the hospital, she did express that her pain was a 7 out of 10.
Counsel, isn't it also true that the officer went because it was suggested by a superior or something that she go to the hospital? It wasn't like she requested to go to the hospital.
It was suggested by her
I'm
superior.
sorry, the officer, I'm not sure if it's a male or female, I apologize.
But her superior probably took note of the fact that she was disoriented. She did testify at trial that she was disoriented, and she had pain in her side, that she had redness in her face, bruises on her neck, abrasions on her arm. Her boss, taking note of all that, suggested that she go to the hospital.
Also, what about the photographs? The photographs don't, if you look at them, obviously we've seen worse.
Well, the photographs, it's important that they were taken almost 5 hours after the attack. After she went to the hospital, she went back to the precinct, and at the precinct, she was photographed. And those
Well,
photographs...
doesn't that go to whether it was substantial pain? If 5 hours later, she didn't really seem to exhibit any lingering effects of the blows?
Well, the photographs have to be taken in conjunction with what happened at the hospital as well. That at the hospital, she did describe her pain as a 7 on a scale of 1 to 10, and doctors did note that she had trauma to her abdomen, which was so concerning that they ordered a CT scan. Those two facts, taken along with the fact that the photographs do still show redness and bruising and abrasions on her arm, all do show that the people proved physical injury at trial. Additionally, the fact that this was an attack by a 225-pound man where he repeatedly punched, elbowed, and hit a 150-pound woman so many times that she couldn't keep count also goes to show that this was physical injury. And this court has previously noted that the forceful nature of an attack can show that the victim suffered more than mere substantial or mere scrapes and bruises. And turning next to defendant's intent, the defendant did not have to intend to cause physical injury. He just had to intend to prevent the officer from carrying out her lawful duty, which was investigating the 911 call. And the people did prove that by showing that he repeatedly refused to follow their request to remain in the bank. Additionally, defendant's sentence should not be reduced on appeal given the forceful nature of this attack and his lengthy criminal record. And if there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Almost every factor that is considered by the court swings in the favor of Mr. Gregory here. She didn't take Advil or Tylenol. In Young, court found that because the complainant didn't take Tylenol and only took 1 week off work, that was insufficient evidence of substantial pain. In another case, in Ray Jose B., insufficient evidence of proof where a complainant was punched several times, sought medical attention, experienced minor soft tissue trauma, prescribed Motrin, no bruising, and had pain for several days that interfered with household chores. She didn't take Advil or Tylenol, only treated with ice, didn't have lasting pain. 2 days, that's People v. Tabachik, that says that very sore, very black and blue upper thigh that did not hurt beyond 2 days, did not reach an objective level to be substantial. And here, we don't even have the complainant testifying that it was very painful. She never said it was very painful. She just said, I had scratches, bruises, and pain to my right side. That's it. She never qualified the pain. And
Didn't she say that when she went to the hospital, it was 7 out of 10, and then later it was a 2 out of 10?
that was a mere number in the medical records, and yes, that does indicate.
But presumably the number comes from what she's saying, right?
Absolutely, Your Honor, it does. But she testified at trial, and despite testifying about her injuries, she never said that it was extraordinarily painful or anything like that. And the 7 does turn into a 5 in a matter of 20 minutes, according to the medical records. And then when she leaves, it's a 2. And in cases where people only take a couple days off of work or take a week off of work, even that, they say, well, they only took a few days off of work. This doesn't sound very serious. She was cleared to return to work immediately, and she works as a police officer, which is a reactive, physical, demanding job. If anything was a little bit off, she wouldn't have been cleared immediately. If there are no further questions, we ask that you.
Thank you. Thank you both. Did I call the case? I'm sorry. Lewis versus 96 Wythe Acquisition. Sorry about that. I'm sitting there. I have the time.
May it please the court, Stephen Donahue for the appellants, defendants, and third-party plaintiffs. So notwithstanding the arguments made in respondent's brief, the issue in this case is not whether plaintiff established prima facie entitlement to summary judgment on his 240 claim. Rather, the issue is whether the defendants and the third-party plaintiff presented sufficient evidence to raise a material question of fact.
So you don't dispute that he made out a prima facie case?
I'm sorry?
You don't dispute that plaintiff made out a prima facie case?
Yeah, that's not the issue in this case.
So I have a question. Why isn't, and I'm aware of the cases, why isn't is dropping this pipe contributory negligence?
If it were you're assuming if it happened the way plaintiff says it happened?
Right.
If it happened the way plaintiff says
Well, not the way plaintiff says it happened. Plaintiff says it happened when another worker came over and moved the thing, and then the beam fell.
Correct.
I'm saying, what about the way plaintiff, the way one of the defendants alleges that plaintiff told them it happened, which is that it dropped. They dropped it.
So if a jury were to credit plaintiff's version of the accident, contributory negligence would not be a factor. It would be irrelevant if it were a 240 case.
That was if they credited plaintiff. I'm saying if they credited the story that one of the defendants said, which was...
If they credit the witness, Joseph Kennedy, his putative...
I'm saying, why isn't it contributory negligence?
Oh, it definitely would be. And not only that, it would not be a 240 case.
Yeah, why wouldn't it be a 240 case, sir?
Because someone dropping an object, letting it slip out of their hands, whether it's a hammer, a gallon of paint, or one of these beams, is not a 240 case. And even plaintiff's expert has not argued that there is any type of protective device that could or should have been provided to plaintiff in order to prevent him from basically letting something slip out of his hands and land on his toe. That's why it's not a 240 case.
But plaintiff's expert says that if in fact the beams were stacked in the way that plaintiff claims, that it would be a 240 case, and that if they were stacked in an unsafe way, then your client, who had the ability to stop work if it was unsafe, could also be liable, right?
That's what his plaintiff's expert says, yes. But that's not the version of the accident that Mr. Kennedy received from plaintiff within minutes of the accident. Plaintiff's testimony, or I mean, Mr. Kenny's testimony is that within minutes of the accident, before plaintiff, had a lawyer and had time to reflect.
Yes, he said that it slipped from his hand.
Right.
But
He was carrying it, and
yes, this was something that was above him, that was stacked, and he had to lift it up, and then he was supposed to lift it to a higher area. Isn't that right?
That's plaintiff's testimony. That's not Mr. Kenny's testimony.
No.
Kenny's testimony is...
The only thing Kenny says is that it slipped from his hand. I'm asking you something different. I'm saying, did it slip from his hand as he was hoisting it above? Because he's saying obviously the plaintiff says he was responsible for taking this thing off of the whatever it was, the barilla, and lifting it to another location that they couldn't use the elevator to take it in. So that's a higher location.
Right.
I'm asking you, if it slipped from that higher point, if he dropped it, if it slipped from his hand from that higher point.
That's not consistent with even plaintiff's own testimony. He doesn't say that he was in the process of lifting this up to some elevated level. He says that there was a stack of, I don't know.
Of the beams on the barilla.
There was like 100 of these 8-foot beams.
Yes, and he said somebody moved it, and then it fell on his foot. Right. I understand. But what they were supposed to be doing was taking it off of the barilla and lifting it to a higher location. right? So that must be, so that if he told Kenny that it slipped when they were in the process of this, I'm saying, wouldn't that be a contributory negligent?
Well, I mean, if the jury believes that explanation, then it might be, but that's not what.
I thought you were simply going to tell me about the Court of Appeals case in Rodriguez and then Autar, but you didn't. So in any case, your time is up and you'll have some rebuttal. And let's hear from the next individual.
Good afternoon. May it please the court. My name is Michael Conway. I represent the defendant, respondent, appellant, All Island Masonry Concrete. I just want to elaborate on one thing. Mr. Kenny testified that the Barella was approximately 3 feet high. So it wasn't something that in Mr. Kenny's version, based on what the plaintiff told him and his.
Yes, I understand. It was 3 feet, which is still a height differential, but it had to go higher than 3 feet because they were supposed to be hoisting it to another level because they couldn't use the elevator to get that thing up. That's my point. It's going from 3 feet to higher. And it was dropped at some point in that procedure and fell on his foot.
Well, that's another one of the questions of fact that are here, Your Honor.
That what I asked was, wouldn't that be contributory? Wouldn't he then be contributory negligent if in the act of taking something from in height differentials and it fell, wouldn't that be contributory negligence within 240 sub 1?
Possibly, but if it depends on the height of the Barella, because there's questions.
You told me it's 3 feet.
If it was 3 feet.
And you told me it was 3 feet.
And he's picking it up off it and drops on his foot, I would.
Picking it up from there and it's going to a higher level. Somewhere in that, it fell.
But that was not the explanation.
All we know is that it fell.
We did, but.
It fell from something, it slipped from his hand.
And he let it fall on his foot. And
well, he didn't, I don't think he put it over his foot and let it fall. It fell somewhere out of his hands. It fell from the process of taking it from 3 feet to higher.
Well, if he was stacking the beams on the Barella and it slipped in that process, that would take it out of the 240, and it could be a sole proximate cause.
If he was packing, you said?
Excuse me?
I didn't hear what you said. If he was what, the Barella?
If he was taking it off the Barella, which is 3 feet high, and it slipped out of his hands, that takes it. That could be a sole proximate cause argument, Your Honor. And to be honest with you, I could have made that motion, but based on the evidence in this case, I wouldn't make it because the plaintiff had a different version. So I respectfully submit that the decision should be reversed because there's questions of fact as to how this accident happened.
Okay, thank you.
Good afternoon. May it please the court. My name is Jeffrey Bloomfield. I represent the plaintiff respondent. Your Honor, we already know it's undisputed that plaintiff met his prima facie. The issue in this case comes down to what Mr. Kenny said. And Mr. Kenny didn't just say a different version. He additionally said after that, that's what he thought plaintiff told me. Indeed, if you read it in total, it is speculation. I refer you to page 753 of the record, where the question is, did he say anything else? Answer, not that I can recall. Question, did he tell you that a beam fell and hit him in his toe? Answer, I just said what I thought he said to me. That testimony shows that it was speculative, that this...
I'm sorry, I'm not following. What was speculative about it? Either happened or didn't happen?
The statement given by the plaintiff to Mr. Kenny.
Well, the statement was either made or it wasn't made, right? I mean, there's no speculation. It's just, you're arguing it's not credible? I mean, what precisely is your argument?
That's correct, that it is a feigned issue of fact. And if you read that paragraph in its total of what was said, it does say, I just said what I thought he said to me.
But that was in the report that was prepared that day?
No.
Did that come out in the report, or was
No.
that only at the later on?
No, that was not in the report. There was nothing actually relevant to Mr. Kenny's version of what was allegedly told him in the report. Mr. Kenny says that plaintiff said he was loading the beams and he let one of them slip. A few questions later, he answers by saying, I just thought that's what plaintiff told me. Moreover...
I don't see how that's speculation. I mean, he's saying honestly, that's what he thinks that the witness, that the plaintiff said to him. And that doesn't strike me as speculation or feigned or anything else. I mean, I have trouble distinguishing that from our decision in Ellerby, where in that case, the plaintiff said one thing to his supervisor at the time and later said something different. This seems to me just like that.
Ellerby is very distinguishable for several reasons. First of all, in that case, the site safety manager spoke to the plaintiff immediately after the accident while he was still on the ground, as well as doing an inspection of the ladder immediately after the fall and doing an accident report contemporaneously on that same day with the same version of the accident. Here, there are complete differences. Mr. Kenny did not witness the accident. He was not there even at the scene when it happened. He only first allegedly spoke to the plaintiff when the plaintiff went from the second floor where the accident happened down to the sidewalk, to the ground level. And at that point, the conversation happened. There was no inspection. There was also no accident report prepared that day. So that issue of...
And the first time it was stated was at deposition.
Correct. Correct. And it was only in that one instance. Moreover, a couple questions later...
Isn't that really credibility for the jury to decide? I mean, because essentially you're saying it's incredible as a matter of law, right?
We're saying it's a feigned issue, and I also point the court's attention to page 763, where he is asked the question about how high they fell. And he's asked, Mr. Lewis was moving the beam when the accident occurred. Do you know how far it fell? He said about 3 feet off the ground. Question, how do you know? Answer, it's a barella, fell off a barella. They were stacking barellas. So here, he's actually changed his testimony. It becomes even more inconsistent now that he's saying it fell off a barella, notwithstanding the fact that he did not witness the accident and did not answer the question of how do you know how far it fell by saying, maybe he told me. Instead, he answers the question by saying it fell off the barella. So
I have 2 questions for you.
Yes.
The first one is, do you have any case law that suggests that when something is stated for the first time in deposition in a labor law case that it's a feigned issue? That's my first question. My second question is, did the plaintiff say, what did the plaintiff say he was doing with the beam? Did he say he was stacking it, or did he say he was moving it from the barella to someplace else?
He said the beams were in position to be moved from the barella from the second floor up to the third floor. They had to do it manually because they were not provided with any kind of equipment, such as a boom or a forklift or a crane. As to your first question, I do not have that, but I do have the First Department case law from Nava Juarez versus Mashalu Fieldstein Realty. May I just finish my point?
Yes.
Which says that hearsay standing alone is insufficient to defeat summary judgment.
Do you want to, yeah, this is, yeah. Well, do you want to give us the citation for that?
Yes, Your Honor. 167 AD 3D 511, First Department, 2018. Thank you.
Thank you.
I don't know that Ellerby is distinguishable on any principled basis just because an accident report was prepared. I don't think the court has to go any further than its decision in Jones versus West 56th Street, which is 33 AD 3D 551, to illustrate that there are certainly material questions of fact regarding credibility and the cause of the accident.
I have 2 questions. Sure. The only photograph in the record of a barilla is a photograph showing 3 of them stacked on top of each other. Are we to understand that that has some relevance to this accident, the stacking of the 3 barillas?
No, I think my recollection is that photograph was part of the plaintiff's expert affidavit and was submitted to illustrate what these things look like when they're used at job sites. I don't think there's any testimony that they were stacked 3 high at the time of this particular event. The last thing I'll just add is with respect, so defendants moved for summary judgment on their negligence claim and 200 claim. The motion court denied that, and not only denied it, but went so far as to grant plaintiff summary judgment on those claims. I think the record's pretty clear that the motion court's decision was pretty untethered to any evidence regarding notice of this condition. The court's statement that this was a condition arising out of some inherent defect in the premises as opposed to the means and methods used by...
Which one is this? Is this means or methods, or is this defective?
This is quite obviously a means and methods case.
And why do you say that?
Because the condition, assuming there was one, of a stack of Barollas and then a stack of beams and then one 16-foot beam placed upon that, was created by plaintiff's employer or the subcontractor, because they're the ones that were doing the work.
Could that be a dangerous condition?
Well, I mean, if you credit plaintiff's testimony, it could be. But it's not a dangerous condition inherent to the property, one that pre-existed the work. They created it.
Does it have to be inherent to the property?
It has to be an existing defect or dangerous condition on the property. Otherwise, if that's not the case, if it's a condition created by a contractor or subcontractor, there has to be evidence that the owner or general contractor or the putative...
It was caused by the means and method of the
and
work that was done.
Right. There was sufficient direction and control over the work that created that condition.
Okay, thank you.
Thank you.
Yeah, we have one more.
I don't have anything further to add other than just to submit that respectfully that the motion court's decision should be reversed.
Okay, thank you. Thank you all.
Thank you.
People versus Malik, Bullock.
Good afternoon, Your Honors. May it please the Court. My name is Desiree Sheridan for Appellant Malik Bullock. In this particular case, the trial court did not have the authority to resentence appellant to consecutive terms by changing the directive of another court. The sentence per se was not illegal. It was the directive that was the issue, the directive that the sentence run consecutive. I would draw your attention to people versus...
It was what the judge did, what he or didn't do. He didn't wait for the other case. He sentenced the defendant before the Bronx case. Was that not, did it not become illegal when he tried to run it consecutively and wasn't, would there be a problem with correcting an illegal sentence?
Well, the sentence per se was not what was really illegal. It was the directive that it run consecutively. So
Isn't that part of the sentence?
I would submit, especially if you read the Barthel case from the Fourth Department, that it's really not part of the sentence. I would consider it separate from the sentence. And in fact, what happened in Barthel and what the defense attorney asked for in this case was for the court to simply strike that consecutive directive. And if they had stricken that consecutive directive, then there would have been no problem with the sentence. It's simply because they ordered...
Would that sentence have been illegal if it had been struck?
If there had been no consecutive directive, then it would have been fine. And in fact, that's what happened in Barthel. And then the court in Barthel acknowledges Clapper and also acknowledges that sending this back or actually vacating the sentence in its entirety and allowing the first court to then resentence is now giving that court power that it didn't have in the first case, which is the power to make the directive whether the sentence runs concurrent or consecutive. And that, I think, should really be the crux of the
With regard to
analysis.
that, counsel, the law is, I think, fairly clear that the power, that decision, that authority rests in the judge who sentences last, correct?
That is correct.
So in this case, one of the what about the notion that defendant didn't get what he bargained for here, right? Because he did bargain for consecutive time.
But then the defendant also bargained for concurrent time in the Bronx case. And again, I don't really think that the people could have any expectation, because if they had read 7025 and known that the sentencing judge who's last in the chain is the one who controls the directive, but for whatever reason at the sentencing on March 15th, the prosecutor says it doesn't matter who sentences in what order, which clearly is not the correct law, but mistake of law is no excuse. So they could not have had an expectation as the first in the sentencing chain that their directive would be the one that controlled.
Are you saying that the parties knew at the time that he was sentenced in Manhattan that they were the first in the sentencing chain? Because I think there's a statement somewhere that the sentencing judge at some point said that it was clear that everyone was under the belief that he had been sentenced in the Bronx.
Well, that's what the sentencing judge said. It was his belief, but then he also says, and I quoted in my brief, he says, oh, I may have missed that in the pre-sentence report.
Well, clearly everyone missed it, right? Because it was in the pre-sentence report.
It was in 2 places in the pre-sentence report that the sentencing in the Bronx wasn't taking place until April 3rd, and this sentencing took place on March 29th. So was the judge careless? Did the judge not care? Whatever the reason was, it's not right to now give this judge power.
Well, let's not just dump it on the judge, right? Because he did ask whether there was any reason why the sentencing should not go forward, and I believe defense counsel remained silent, and the people, I don't know what they were doing.
Well, exactly. The people also, they could have spoken up as well. So they could not have had an expectation that they were going to get the directive in their favor when they were the first in the sentencing chain. But I particularly think that Barthel is very cogent, because they say you can't give this judge now power they didn't have in the first instance. And that's what they're asking, and that's what the trial judge was trying to do, was to try to usurp power from the Bronx court and take power that he didn't have to make the directive in the first instance. And so the proper remedy is to really just strike that consecutive directive.
Does it matter that in Barthel the defendant was convicted after a trial?
I mean, they didn't seem to make an issue with that in the case, so I don't know that that's.
Well, I'm saying it wasn't in the Barthel case, but I'm saying does it distinguish this case based on what my colleague said, that here there was this bargained for sentence, where in Barthel it was a trial, it was a verdict after a trial.
I mean, I don't think it does, because it still boils down to the sentencing order and who has control in the order of the sentencing and who has the right to declare whether the sentence is going to be consecutive or concurrent. So I don't think the nature of how they get to the sentencing, whether it's by plea or whether it's by trial, I don't think should be determinative. I think that the issue is that the judge should not be permitted to have power that they didn't have in the first instance. And were to just, remedy a length of time, that would be one thing, but then to be able to direct whether the sentence goes.
Well, here on resentencing, the defendant was sentenced to the exact same thing that he was sentenced to originally, correct?
Well, that's the point, and that's why I think that this case is distinguishable from cases my adversary has cited, because in those cases, the actual sentence was changed. There was a resentencing which involved different time calculations. That's not what happened here. It was clearly the judge trying to correct or trying to now take power to decide whether it was concurrent or consecutive, power he didn't have by being the first in the sentencing chain. And had he simply waited until after the Bronx judge had sentenced defendant, then that would not have been an issue.
So I'm confused about you using the phrase power, because if he had just adjourned it, he would have had the power to do this, right?
Yes, if he had adjourned it as well. But so he was trying to exert authority he didn't have as the first judge in the sentencing chain.
Is that really what it is? No, it was just a mistake.
I'm sorry?
It was a mistake. It was sloppiness. It was a mistake.
I mean, you could say it was a mistake, but I don't think, I think that here was just being
Well, did anyone,
careless.
it's been pointed out, it was never raised to the judge, and maybe he looked at the report, maybe he didn't. But had it been raised and he did what he did, I think you'd have a stronger argument, no?
But it was raised to him. In fact, at the very first sentencing proceeding, I think it was March 1st or something, he asks for the pre-sentence report. He doesn't want to go forward until a pre-sentence report has been issued. They get the pre-sentence report on March 15th. Had he, assuming he read that pre-sentence report because it was so important to him, and in 2 separate places it said it in the pre-sentence report, the Bronx sentence hadn't taken place yet. So for whatever reason, he just still chose to sentence Appellant, and it's not right now that he can come back and have this authority to decide that it's a consecutive and not concurrent sentence that he didn't have in the first place.
Thank you.
Good afternoon, Your Honors. Michael Tarpon for the people. Your Honor, Justice Renwick, as to your question about whether it makes a difference whether this was a trial or a plea, in People v. Barthel, the Fourth Department did distinguish that. In footnote 4, the Fourth Department says we're not deciding that a resentence for a reimposition of a consecutive sentence would be inappropriate if the defendant had bargained for a consecutive sentence. That would be different, and that's exactly what happened here.
Counsel, to the extent that the Manhattan sentence was illegal, couldn't it have just been corrected by striking the consecutive requirement?
No, Your Honor, it couldn't have. That's what the court in Barthel did, but that was the appellate division did that under 47020 by modifying the illegal sentence. Of course, the sentencing court in Manhattan didn't have the authority under 47020. It's not an appellate court. Its only option, its only remedy it could give was to vacate the illegal sentence and then resentence the defendant. And when it resentenced the defendant, it actually had to give a consecutive rather than a concurrent term because under 7025-2B, the defendant had to have a consecutive sentence because he had committed the Manhattan crime when he was out on bail for the Bronx crimes. Further, Your Honors, the Manhattan court did in fact have to resentence the defendant because his initial sentence was illegal because it was premature. This court made clear...
I'm sorry, it was illegal because it was premature?
It was premature. He gave consecutive time.
It was illegal because he gave consecutive time. This whole thing about premature, the judge chose for it to be premature, right, by going forward or not realizing that the Bronx sentence had been imposed.
Right, right.
I think using the word premature is not accurate here, not correct.
Sure, Your Honor. I merely wanted to point out that he would have had that authority had he realized the Bronx sentence hadn't
right, but that's your adversary's point, that the structure of the law is that you want to give the judge that goes second in time.
Right.
That's the judge that is vested with the authority to decide whether it's consecutive or not. And by what happened here is you stripped the second judge of that authority, right? The Manhattan judge stripped the second judge of that authority simply by... I think it's clear that the whole purpose of the resentencing was to make it run concurrent, to make it run consecutive. That's it. Because other than that, there was nothing unlawful about the sentence, correct? It could have happened. He reimposed the same sentence.
He had to give consecutive time, and he couldn't. This case was sent back. The judge here didn't resentence it because the Bronx judge is something different. He resentenced the defendant because corrections sent back and said, you can't give consecutive time now. This is premature. The Bronx sentence hasn't been imposed yet. And the judge apparently asked the parties, what do we do? Defense counsel says, strike the concurrent, and the people said, no, resentence him. And, Your Honor, I have to disagree that the second judge in the chain has the authority. It's the last judge.
It's the last judge, that's correct.
Right, in Murray v. Gord, it makes it clear it's the last judge, even if that judge was the first judge originally. That doesn't matter.
We could just keep going like that.
Right.
Actually, you couldn't, Your Honors, because the only reason the Manhattan judge could resentence the defendant is not because the Bronx judge did something different, but because the Manhattan judge's original sentence was illegal. Had it been legal, he couldn't have done anything. And actually, right now, he couldn't do anything. If the defendant went back to the Bronx and got a concurrent time with a finding of mitigating circumstances or something, the Manhattan judge couldn't do anything because
Which did not happen, right? I mean, part of the whole thing here is also that the Bronx judge, there's some question about whether that sentence was legal because the Bronx judge didn't find mitigation as required under the statute.
Right.
So in theory, now the Bronx judge could vacate his own sentence and resentence consecutively.
He could, but it would end there. This is an unusual case where they're
He could, but, I'm sorry, he could, but it would end there.
In there, there would be no
Right,
finale
but
problem.
it would be the second time, and then he'd be back to where he was.
Right. Now, the judge couldn't do that because there are no mitigating circumstances. The defendant hasn't even proposed anything. But in theory, had there been, because that initial Bronx sentence was illegal, the judge could resentence there, but that would be the end of it. The Manhattan judge has corrected his illegal
I think we've got it.
Sure, Your Honors. Thank you.
Thank you.
I just briefly wanted to respond that, yes, in terms of the Bronx sentence, if my adversary is complaining about the sentence that was imposed in the Bronx, then that's for the Bronx DA to go and argue. That's not for the Manhattan court to go and argue about. And moreover, it actually does encourage the kind of leapfrogging that Barthel criticized, that you can just keep usurping the next judge's power and keep resentencing and resentencing. And essentially, really, this was
within limits, because it's got to be illegal. There's got to be a problem with it.
But it's the sentence that itself was not illegal. It's just the directive, which again, you can cure that illegal directive by simply striking that directive. And that's what should have happened here, as defense counsel asked in the first place. And I just wanted to also briefly ask that the surcharges and fees be waived, as was mentioned in the supplemental brief. And if there are no further questions,
What about the other fees? You're only asking about the fees within the new statute.
Yeah, the
Presume.
fees that were imposed on an appellant, I think they totaled $375 or, yes.
Yes, thank you.
Yes, thank you.
Thank you both. Miller versus Camelot Communications.
Good afternoon. May it please the court, Sim Shapiro on behalf of the defendants appellants. There are obviously a number of issues on this appeal, but I'd like to focus on the primary one, which is the exchange or the allegation that it wasn't exchange of that deposition transcript from the prior action.
Counsel,
well as,
I have a question about that. Whether or not that was properly exchanged, didn't trial counsel, defendant's trial counsel, have an enormous opportunity to question plaintiff and her doctors about the effect on her of the Lincoln Center incident and how that interacted with whatever happened to her in the case at bar? So if they were already, if they had the opportunity to question about that, how was defendant really harmed by not being able to question about the deposition?
and the reason is, the answer to that question is because he was deprived of the opportunity to cross-examine this witness who said some very, very divergent testimony.
I understand that from a lawyer's point of view, there's,
I'm sorry.
excuse me, I understand from a lawyer's point of view that you weren't allowed to do certain things, but in terms of getting out to the jury the information about how the plaintiff was affected by the other accident, wasn't that opportunity available to defense counsel?
One of the reasons that it wasn't is because by the time defense counsel, Mr. Weiser, was cross-examining the plaintiff had already testified that she was really just fine. In fact, she literally said, I was fine during direct examination. So if the suggestion is, look, he can cross her and say, wait a minute, isn't it true that you weren't fine? He has nothing to base that on because he can't use that transcript anymore. And she's already told the jury, oh, I was fine. I was able to perform and I was doing all this thing. She testifies that on the date of the incident, and this is all at trial, on the date of the incident, I was able to take, unpack all the items from my show, and really up until that day, I was really just fine. And so that was already on direct. And he's got nothing to fall back on under the cross other than to maybe take a risk and have her reiterate the testimony she just gave to her attorney. And he's got.
So you mean that was his first opportunity to say anything with regard to this information?
I'm sorry, Your Honor.
That was the defense counsel's first opportunity to raise any of those issues with regard to the Lincoln Center? That was the first question? That was the first time it came up?
Yes, because at that point, she's already given her testimony. The jury's already heard, hey, look, until December 13th.
Yes, I understand. You just said that part. Yeah.
Right, so that is his first opportunity.
But one of the doctors who testified for her had also examined her after the Lincoln Center incident. So certainly defense counsel could have questioned that doctor about whether or not the first incident caused injury that was still ongoing. Why not?
He could not, because he actually asked that doctor if he'd seen the prior records, and the doctor said he hadn't. Doctor said he'd asked for the prior records and wasn't given them, and it was very clear that the doctor said, I don't believe, as an example, he said, she was testifying, she was treating with a psychiatrist was a question. He said, no, I don't believe she was. And of course, and when he was challenged on that, and there is an example of cross-examination, and Dr. Guy said, well, I don't know that, they didn't give me the records.
But there was one of the doctors had examined her in the context of the earlier accident as well as the car, as well as this incident, right?
But Dr. Guy's testimony, which is obviously their critical expert, had said, and he was cross-examined on that, were you given the records? And he said, no, I asked for them, but I was not given those records. So that really deprives defense counsel the opportunity to cross-examine. You have very, very divergent testimony from a plaintiff who at one point is saying, to give a couple of examples, okay? She's saying at trial, just to give you, just one. She said, I was performing 8 weeks after I had the surgery all the way up to the accident. She told the jury, she literally used the words, treated and resolved. And you have a question and answer, if you look, for example, on 295 and 296 of the record, where she's asked, were you able to perform? Were you able to act? Were you able to dance? Yes, yes, yes. Compare that with her sworn testimony from 2 months before the accident, and on a transcript that we know she had. And we know her lawyer in this case for the first 2 years had literally sitting in her office, and there she says, just the opposite. They wanted 3 days a week. I couldn't do it physically anymore. 1 day at most, 1 day every 2 weeks at the most.
Weren't you able to get in discovery the records of how much she performed? Why wasn't this something that you were able to establish through other evidence?
I think that's a very difficult, that's a very difficult type of document to obtain, how many times she's gotten. But Your Honor, if I may say, there's no substitute for sworn testimony, as opposed to, as an example, Your Honor, because apropos of your example, she was put under surveillance and was actually shown after the incident performing a show. And she explained, oh, well, I was performing, but not as well, and I was in a lot of pain, and you can't see it there. I was trying to smile. I was trying to give them a good show. So even if we had records showing that, in fact, she was performing or not performing, she might have had an explanation. That's very different from sworn testimony under oath. Not at all the same thing, very much apples and oranges. And this jury was deprived of the opportunity to hear that. I do realize I'm out of time. I do want to point out this was hardly the only issue at trial. And again, I realize you've read my brief and all the documentation. We have a 2,000-page record, but one in particular where we have jurors already deliberating for about 45 minutes at least, and then being read a completely different statute than they'd already been told by the judge. And when it was, my colleague asked for...
You do have 2 minutes of rebuttal where you could discuss that, but I'll give you 30 seconds to address that, as the fact is the judge gave the correct charge, and prior to giving the correct charge, he said something like, there is no question that that intersection was controlled by a device. And then he proceeded to give the correct charge. Before, he had given a charge that talked about where there was no device. So clearly now he's saying, jury, this is the fact here. There was a device. No question anymore about the other thing. Without saying that, jurors are supposed to listen to the court, and we, presume that they abide and follow the court's directives. And if they have a question or they're confused, they send a note. No such thing happened here.
If I may, Your Honor, I do realize I only have 30 seconds on that. The problem is we can't assume that they're going to be able to say, well, what did you mean? Why did you do this? There was no explanation given to them, and I pointed out in my brief that, in fact, in the first statute, the language that was used is there's a claim. The second time there was not. So there's an implication of, okay, actually the plaintiff was in the crosswalk, because that's the language of that second statute. And the jurors don't know.
But it has nothing to do with the plaintiff. The court never said anything about the plaintiff. The court only talked about the device, meaning the lights. There was no question about that.
There's also, absolutely, that part of it, absolutely. But there's also reference to the crosswalk in that statute.
In the statute?
Correct. That was
read to
them.
But it's the correct statute.
That was read to them.
That was read to them before you're saying the first statute or the second one?
The
second one, which was the correct one.
I understand, Your Honor, but when you make a modification, there needs to be an explanation, especially when you have.
It would be best if there was an explanation, but that doesn't mean that what was given was not sufficient, because there is the forgetting what it's called, but the of regularity, the expectation of regularity, and that the judges and that the jury's going to listen. Anyway,
I think here it does.
More than 30 seconds.
Yes, and I'll address that more on my rebuttal.
Okay.
May it please the court, my name is Joshua Kellner, and I represent the plaintiff respondent, Linda Miller. So if I might, I'd just like to start by trying to dispel a little bit of confusion that I think may have arisen during my colleague's presentation. First, there's no question that this transcript and the IME questionnaire was not exchanged in context of this case. It may have been exchanged with the plaintiff's prior attorneys in the case it was taken, the deposition transcript, not the questionnaire, but it was not exchanged here.
Counsel, let's assume for the purpose of my question it was error. So the question I have is, was it harmless error? Was the defendant deprived in any way of getting out the evidence that the defendant needed to get out with respect to the prior trial, specifically relating to the issues of injury and sequela?
Sure, I'll take the question on its own terms. Assuming there was an abuse of discretion, it was harmless error. First of all, they knew what medical records to subpoena in relation to the prior accident.
So do they have the medical records?
They had authorizations for it. Dr. Head, who was their examining doctor, his report from this case is exchanged at, it's at 1865 of the record. And he has a lengthy addendum where he was shown and discusses all of her prior treatment records from that accident. They made a tactical choice not to put those records in through Dr. Head, because when he saw her in connection with the prior case, he said she was totally fine with no lingering disability. Second, they could have put the records in and just crossed Miss Miller on it. Didn't you tell this doctor such? Didn't you tell this doctor so? They didn't do that either. Third, they had the opportunity to get employment records, and that's part of the PC order, and the court can draw whatever inferences it will about whether that was exchanged.
So what about your adversary's position that all that you speak of is not the same as having the person's sworn testimony?
Well, if defendants wanted to make use of the testimony, all they had to do was comply with the court's order and exchange it. The court directed that party statements be exchanged. It was in the CSO. They didn't exchange it. And this is true of discovery in general. The CPLR...
So let's assume that there'd never been a substitution in this case. Would the argument hold that the EBT transcript from the prior case couldn't be used in this trial?
Absolutely, Your Honor, because what the CPLR said and what the CSO said is...
Well, even if everyone knows, the plaintiff knows about it, the attorney knows about it, the rule is the rule.
Well, the rule is the rule, and also what I would add here is that their post hoc rationalization is we didn't have to exchange it because we thought they might know that it existed. If that was their position, it was incumbent on them to put it in writing in response to the CSO. Say, we're in possession of party statements that are responsive to this order, but we don't think we have to exchange them because we think that you might know that they exist.
So counsel, but trial counsel for your client said at 571 of the record that if the same counsel had represented plaintiff in the two cases, then defendant would not have been under an obligation to turn those over. Are you disagreeing with what your trial counsel said?
Your Honor, I don't read his statement quite the way that Your Honor does, but the law is the law. They failed to comply with the CSO.
You know, I'd like to go back to the, I'd like to go back to the issue with regard to the documents that counsel would have been able to have without the deposition. So that he was prevented from using the deposition. You're saying on his direct case, after the court, well, the court didn't allow it because she said he was supposed to exchange it, that there was no testimony from any doctors or anything else.
Well, they didn't elicit it because they didn't subpoena the records from the prior accident and bring them into evidence. And so there's a colloquy before Dr. Head, who did see these records, testified, where defense counsel says the records from the prior accident aren't in evidence. I don't intend to ask him about it. But that was their decision about how they wanted to try their case. They had the authorizations. They knew who the doctors were. They simply failed to subpoena them to the courthouse. Instead, what they chose to do is put all of their eggs in the basket of doing trial by ambush, of ignoring the CSO, not disclosing that they had the materials.
Well, wouldn't that be a better argument if, in fact, plaintiff didn't know about the EBT or you didn't, trial counsel didn't know about the EBT? It's really not trial by ambush. Maybe it's not technical compliance with the rules.
Well, it's not compliant with the rule, and it's also a failure to disclose what their position was. Because they didn't say, well, we have these materials, but we don't think we have to disclose them in response to the order. They hid the fact that they had them at all.
But even after that, they still would have been able to address this issue by identifying through the doctor, whatever medical, or through medical reports.
Dr. Head, again, their examining doctor in this case, and Lincoln Center's examining doctor in the prior case, reviewed all of the records from the prior accident in context of this very case. It was simply
Of course, that costs a lot of money because now you have to put your doctors on the stand.
I'm sorry, Your Honor?
Then you have to put your doctors on the stand.
Well, they put their doctor on the stand. They just didn't ask him about it because by their own acknowledgement, they failed to introduce the records and evidence and therefore couldn't. And that's a failing on their part. And I guess what I would just return to is the idea of what the discovery obligation is.
Actually,
The CPLR...
could you address the second issue, because you're running out of time? Was it reversible error to give the correct charge in the middle of jury deliberations without explanation, et cetera?
No, I mean, I think, first of all, defense counsel didn't object to bringing the jury back in as to the factual portion of the charge. In fact, that part of it was drafted cooperatively by the attorneys. And then the second part of it, I think Your Honor's question answers the question, which is to charge the correct law. And the law didn't favor either position. What it said is if you're vehicular traffic and you have a green light, you can make a left, which is Mr. Almonte's testimony. And if you're a pedestrian and you have a signal in your favor, you can cross in a crosswalk. So it's not a charge that favors either side or materially alters the framework within the case was tried. If I might, and I see my time is up, if I can just add 30 more seconds on the issue of the party statements.
Okay.
As we talk, a case that the Court of Appeals decided in Tai Tran versus New Rochelle Hospital comes to my mind. And that was a case about surveillance videotapes. And it was the case that said that you have to produce them before party depositions because the CPLR doesn't draw a distinction and say you don't need to produce it until after, just based on credibility challenges. And that all goes to the design of the CPLR, which abhors trial by ambush and doesn't say you can hold back evidence based on qualifications that you carve out yourself. Here, they had the evidence, the court directed that it be produced, they chose to violate the order, and whether or not they believed that plaintiff's prior counsel had possession of it or knew that it existed, it didn't affect their obligation to produce those documents. And indeed, at page 398 of the record, plaintiff's trial counsel here read the demand that was served at the beginning of discovery by plaintiff's original attorneys, which said, produce party statements, however obtained. They violated the order, and the motion court, the trial court, did not abuse its discretion in penalizing them for that decision. Thank you, Your Honors.
Thank you.
Good afternoon again. Respectfully, my colleague is incorrect when there's a sense of, oh, I think that the other lawyer has it. There's no I think. They know. And as Your Honor pointed out, actually, trial counsel acknowledged on the record on page 571, look, if they were still in the case, he'd be correct. And there's a reason for that. It's literally sitting in their office. There's no dispute about that. I've actually produced as part of the record the disclosure of those items from the prior action.
But we don't know
that. That's not an issue of I think, it's I know.
Excuse me, we don't know that as to the IME record.
We do.
Right.
We do. It's there as well. It's in the record as well. So I appreciate that there might have been a little bit of confusion about that because initially I didn't actually receive a copy of that, but it's actually included in the record on appeal with an affidavit of service. So that was included in the disclosure of the IME from the prior lawsuit. I can direct Your Honor to the citation, the record on that as well. So be that as it may, the bottom line is, in fact, they were very much aware. Beyond that, by the way, it's page 1967 of the record. Beyond that, I think that even if you were to obtain medical records, and even if you were able to somehow obtain records of performances, which is not so simple to do. And mind you, there was a statement from the new counsel that, oh, we're not making a claim for lost earnings. So it's a good question of what might have been discoverable or otherwise. But beyond that, there's testimony here from a live person that goes beyond what medical records might say. Medical records might say range of motion is this or that. When a person, a real live human being, mind you, the plaintiff who's sitting in front of this jury, says under oath, I couldn't do it physically anymore. One day at most, every two weeks at the most. When it opens back up only once a month, I get exhausted quicker. I don't have longevity. I get dizzy from dancing. I could have done 3 shows a week any other time. I come off the stage and I pass out. I have to keep lyrics on my dressing room lined up before I go out. I look at them and then go out. That's not going to be in medical records. And there's no substitute for sworn testimony. And we have here a request for really an unprecedented, and there's no appellate case that's ever supported preclusion, because the statute itself doesn't talk about shall produce, it's may produce if there's a request for it. Obviously, the attorney who had this the whole time didn't request it because he had it. So there's not even an issue. Same thing with the IME questionnaire. And so I think ultimately it goes back to the voice of the plaintiff. Even if I had a stack of medical records, there's no substitute for that, and the jury was deprived of that. And I must point out, it's very critical, even more so in this case, because here there was no claim of exacerbation. So the jurors really need to decide, hey, did these injuries originate from this incident? Because if they didn't, if it's an exacerbation, if we think, hey, look, Ms. Miller was injured, but it aggravated her prior head injury, her prior neck injury, they cannot give an award for that by law in New York. So in this particular case, it's especially critical. And beyond that, unless the court has any questions, I'll rely on my brief.
Thank you. Thank you both.
Thank you. Thank you.